Fresh matter sir ಕೊಡಿ. Fresh matter sir ಕೊಡಿ, please give. Extend the entry model.
My lord, serial number 43, my lord.
Please
Serial-
wait, madam.
Sorry.
Huh? Here, what are you filing? How can you file a memo for extending an interim order? Madam, you can only ask for posting the matter. You can't ask for extension of the interim order by filing a memo. Yes. Yes. Adjournments only if the other side is present here and says no objection. Otherwise, please do not move the court for adjournment. Yes. Informed alla illa. They have to be here. 29. Is the other side here? Did you hear what I said? Is the other side here? Is the other side here? Don't move the court.
Number one. First matter, serial number 1. Your Honor, exceed.
ಏನು ಆಗ್ಲೇ ಕ್ಯಾಲೆಂಡರ್ ಆಫ್ ಇವೆಂಟ್ಸ್ ಇಶ್ಯೂ ಮಾಡ್ತಾ ಇದಾರಂತಲ್ಲ, ಏನು ಮಾಡಕ್ ಆಗಲ್ಲ ಸರ್. we'll have to issue notice to them. I can't pass interim orders like this, staying the process. Let them take notice, we'll see. Then at ATA takes notice for response number 1 and 2. ಯಾವ್ದ್ರಲ್ಲೂ ನಾನು I have not granted any interim order. Yes, let us see. ಹಂಗಾರೆ ನೋಡೋಣ, let us pass over. ಕೊಡಿ.
Madam, may I seek permission?
Yes.
List serial number 1, Kalaburgi bench matter, my lord. Judgment correction. There is a name of the
ಹೇಳಿ ನೀವು ಕರೀರಿ ಅದನ್ನ.
name of the petitioner.
This pertaining to Kalburgi bench, hearing into application. Serial number 1. DP Ambedkar. DP Ambedkar.
Yes.
In this matter, my lord, final order of judgment, my lord, name of the petitioner Sharan Basappa is mentioned, my lord, instead of Sharan Basava, my lord. As per other
ಇಲ್ಲಮ್ಮ.
final order of petition, my lord. Sri Sharan Basappa. That has to be Sharan Basava, my lord.
ಇಲ್ಲಮ್ಮ, where is it?
Aadhaar card I have produced, my lord.
Madam, it name of the club is correctly mentioned.
Sharan Basappa, that's not a Sharan Basappa, my
It
lord.
is irrelevant.
Sharan
The petitioner is a club. Mentioning of the name of the proprietor or the secretary wrongly will not make any difference. We are only concerned with the club. ಏನು ನೀವು, what is this? Does it make any difference by showing the name of the secretary wrongly?
Yes, my
Is the
lord.
petitioner club important or the name of the secretary is important? Huh?
Name to be otherwise petitioner will suffer, my lord.
Why?
If Sharan Basappa is different from Sharan Basappa, my lord. Names.
ಅಮ್ಮ ದಯವಿಟ್ಟು ಅರ್ಥ ಮಾಡ್ಕೊಳ್ಳಿ, petitioner is the club. ಆ ಹೆಸರಲ್ಲಿ ಏನಾದ್ರು ತಪ್ಪಾಗಿದ್ಯಾ? ಮತ್ತೆ ಸುಮ್ಮನೆ ಏನು ಇಲ್ದಿರೋದ್ನೆಲ್ಲ ತಗೊಂಡ್ಬಂದು ನೀವು ಕೋರ್ಟ್ ಅಲ್ಲಿ ಯು ಆರ್ ವೇಸ್ಟಿಂಗ್ ದಿ ಟೈಮ್ ಆಫ್ ದಿ ಕೋರ್ಟ್. ಬರ್ಕೊಳ್ಳಿ. Order on IN number 1 of 2020. This writ petition was disposed of on 4th of July 2020. ಏನಮ್ಮ 3 ವರ್ಷ ಆಯ್ತು ಆಗ್ಲೇ. ಇವಾಗ ಬಂದು ಇದನ್ನೇನೋ ಹೆಸರಲ್ಲೇನೋ ತಪ್ಪಾಗಿದೆ ಅನ್ಬಿಟ್ಟು ಏನೋ ನಿಮ್ಗೆ ಭಾರಿ ಇಂಜಸ್ಟಿಸ್ ಆಗ್ಬಿಟ್ಟಿದೆ ಅನ್ನೋ ತರ ಕರೆಕ್ಷನ್ ಕೇಳ್ತಾ ಇದ್ದೀರಾ. Is there any meaning in this? With certain directions to the respondent police. So, however, it is now contended that the name of the secretary of the petitioner club is wrongly shown, and therefore correction is sought. Stop. In the considered opinion of this court, the application is meaningless. It is a waste of precious public time. Stop. The name of the petitioner club is correctly shown. It is only contended that the name of the secretary is wrongly shown. Stop. The name of the secretary hardly makes any difference or has any specific value attached to the order. Stop. Next para. Nevertheless, since this application is moved from Kalburgi, office is directed to. Where is the information regarding the correct name of this person?
Aadhaar card is produced, madam, along with ID.
Ivaga.
Yes, madam.
Then you have to seek correction in the cost title.
Petitioner.
Where you
Aadhaar card is produced, madam, at page number 4, madam.
Nevertheless, since this application is moved from Kalburgi bench, office is directed to
permit the petitioner to correct the cost title showing the name of the secretary as Sharana Basava in place of Sharana Basava. Stop. After amendment is carried out, a fresh certified copy may be issued. Full stop. Ordered accordingly. Tell your senior.
Yes,
This is
madam.
what the court said. Before
Yes,
making applications, you should apply your mind.
Yes, madam.
Yes.
Number 1, preliminary. Number 2, Ajit Kalyan.
Huh? KHP. It's not a local body matter. Office is directed to classify this matter as GM, KHP. Reclassify this matter having regard to the fact that the matter arises out of the Karnataka Housing Board Act. 1962. And thereafter, place this matter before the bench having roster. Same. Hmm.
Now the responsible for and five, rather to facilitate certain the real estate agent and real estate developer. They want to follow the road. In a land. I'm not on the road in accordance with the acquiring, take it and follow the road. Though there is no such indication in the progress sketch, it also in the grade map for the road. So they want to follow the 20 feet road, I expected. Instead of the thing now, these they want to do it, I have made a representation. I representation in the
HCGP takes notice for response number 1 to 3. ಈ ಕೋಲಾರ CMC ಯಾರ ಪೇರ್ ಹಾಕ್ತಾರೆ? Issue emergent notice to respond number 4. ಇವರು HCGP for response number 1 to 3 and 5. Issue emergent notice to respond number 4. The petitioner is also permitted to take out hand summons to respond number 4. Learned counsel for petitioner is directed to serve a copy of the petition on the learned HCGP. Full stop. Next para. Learned HCGP is required to take instructions from the fifth respondent, Tahsildar, from Kolar Taluk, as to whether there is any proposal to form a road on the property belonging to the petitioner. Full stop. Release this matter on 12th of July. You have not placed any material. Let us see. ಇನ್ನೊಂದು ವಾರದಲ್ಲಿ ಏನು ಆಗಲ್ಲ ಬಿಡಿ ಸರ್.
ಪ್ರಸಾದ್
Learned counsel Sri E.V. Gangadharappa is requested to take notice for the respondent. Learned counsel for petitioner is directed to serve 2 sets of petition along with annexure on learned counsel for the respondent. Release this matter on 12th of July. We'll see. Pass over. Copy sir ಮಾಡಿ. Yes. You want to appear for the respondent. You not file vakalat. Vignesh Shetty. 2, 3 and 4. What about respond number 1, Canara Bank? Then why did you make him a party? Sorry. How can they be pulled to the arbitration now? If they are not parties to the agreement.
They are party to the agreement. Supply was made second response. Then under the agreement. The second response is subsidiary, earlier subsidiary.
Which is the agreement annexure A na? Between syndicate bank.
Now it has. Corresponding with the subsidiary of the. I was made to be second.
Anyway, they have been made parties. If they don't come, what should happen? It's served. Bengaluru, please take out handsome. The petitioner is permitted to take out hand summons to respond number 1, since the agreement at annexure A is entered between the first respondent and the petitioner. Yes. Please give it. Learned counsel for the respondent submits that the statement of objections are ready and the same will be filed in the office during the course of the day. A copy of the objections are served on the learned counsel for petitioner. Full stop. At the request of the learned counsel for respondent, release this matter on 12th of July.
This is section 11 notice.
The lease deed is at annex A 2010. The lease deed was entered in year 2010.
Annex B, I terminated lease. Because the arbitration clause in annex A. The approach district court section 9.
The other side.
This one.
And
district was pleased to pass a unit order and then because of the person they issued section 11 notice.
Who issued?
Respondents.
Ah.
I was not agreeable with the suggested nominated arbitrators. I disagreed and nominated suggested another arbitrator, which again they were not agreeable.
Yes.
Since they did not concede, I have there is a section 9 application pending.
Yes. We will appoint the arbitrator. We will appoint the arbitrator. There is no dispute regarding the arbitration clause contained in the lease deed. Sir, matter the issue, the law is well settled. Even if an agreement comes to an end, the arbitration clause will continue to resolve all the disputes that arise out of the agreement, even if it is terminated. That is the law. Yes. Sir, you have suggested a name of an arbitrator. They have also suggested a name of an arbitrator. Both of you are not agreeing for the arbitrator. This court will appoint the arbitrator. Yes.
They became director, effective from 1522, and they are not disclosed in the petition. That report meaning of the petition is not indicated.
Raj Safari Limited.
Also,
Private Limited. Raj Safari Private Limited.
this is government Nagaraj and Nagaraj. They have made 3 more crore in the debt tribunal for petition 1 and 2, and thereby they have sold away the property. They have not disclosed it. Without disclosing the same that in order to entrust my property to government Nagaraj and Nagaraj. It is very cleverly filed to present petition. Therefore, my lord.
Yeah, I'm not able to understand. This is a lease deal under which Rudra Pratap Singh and Shruti Kirti Devi,
Yes, ma'am.
Are
They are
you
the
first?
they are the owners.
directors, sir.
These are the lessees.
The tripartite agreement.
Huh?
The tripartite agreement.
Tripartite agreement.
Petition number 1 is on the first part. Petition number 3 is on the second part. The
Huh?
restaurant is on the third part.
We-
What
Ah.
is the current is suggesting is-
Siddhartha Resorts.
Yes.
So there are 3 parties.
Yes, ma'am.
What the current is suggesting is that Manu and Gaurama are directors of restaurant number 3. It's a company. And they are not directors, they are shareholders, they are not directors, it's a company.
Yeah, they are parted with the Gaurama Nagaraj and Nagaraj money. Thereby, currently became directors. You did. Because they.
Allah, you are representing whom?
I am representing Rassi, madam.
Huh?
Rassi.
Who is the lessee?
But if these are
Siddhartha Resorts. Siddhartha Resort. You are the lessee.
Yes.
Ah.
No, madam.
Ah.
They came to my.
Yes.
And demanding a vacant portion from us. And thereby we have discovered in the ROC, that they became directors. If you very petitioner, they are not
Directors of
of the third petitioner company. They are not disclosing their petition. We heard that if this property has been entrusted to them for money, they have allocated.
they are the
In terms of the legal agreement.
7 nimisha. Rudra Pratap Singh and Shruti Kirti are the owners.
Yes.
Who is this Raj Safari?
That safari added by them only their family member. One may not be father of.
Confirming party. ಏನ್ರಿ ಇದು? Please explain properly. I am not able to understand. Why there are 3 parties in the agreement?
Because there is another agreement which gives the license to run a resort. But there's another agreement which gives the license to run a resort.
Huh.
But since it also contains certain monetary effect because of running the resort, they are paid confirming for the resort. But property is not sold away to Mr. Manu or Golam. What is suggesting is that the directors of petition number 3, change in direction should not matter. They are not directors.
You are only a lessee. You are only a lessee. Whether this Rudra Pratap Singh and Shruti Kirti have sold the property in favor of Raj Safari or not, how does it matter? Hmm.
Because may not invested the four books are right close to good. Yeah. Where there was a dispute by one bank.
How are you concerned with that, sir?
I have taken my contention.
In contention, what is your contention? You are only a lessee.
Yes, madam.
Yeah, for some reason they have terminated. Who terminated the contract? Who terminated the contract? Yes,
They have not terminated the contract.
whatever it is. Now there is a dispute.
Whatever.
There is a dispute arising out of the contract. That if a dispute arises, it has to be settled through arbitration. There is an arbitration clause.
So that, not be appointed because of the reason that they are sold with the business to the government and.
So?
Here we not. The successor. They have to get it done by way of tenancy. Installment of tenancy.
Who are that purchaser? Who are they are not parties here.
They have not made party.
Not necessary. Yen cleverly ella enilla. You are only a lessee. There is a dispute arising out of the agreement. They want the matter disputes to be settled under the arbitration clause. If you have any contentions to make, you make before the arbitrator.
No, when resorts are not.
If a contract contains an arbitration clause, they are entitled to have the dispute resolved.
Very clear. As financial year. When the resorts are not the owners, as long today, how can they,
They have not come before the court, sir.
petitioner have no understanding.
Why they don't have locus?
Property, government, Nagaraj Manu.
So
So they have to make it a NS adornment now.
where is that document?
I will produce, but I have not done. India.
At the end of 6 months, if there is section 9, presentation is section 11 notice again to me. This is just a delay.
Is it a fact that you have sold away the property?
Why any condition will be raised before the tribunal?
Huh?
All these conditions will be raised before the tribunal.
That's,
I don't have tribunal to decide.
the arbitration clause will not.
Any high court judge may
not
provide
exist. In terms of annexure, yeah, you say last.
Sir, even if you bring a document which shows that they have sold the property, nevertheless, the contract survives. There is no attornment.
Contract survives.
You have not been paying the lease amount to the subsequent purchasers. Nothing.
What happened? Lessors are no more owners. And their way class 25 will not exist for any.
By which law, sir? By which law?
They have lost the.
By which law, sir? You please tell me by which law they have lost the right to have the dispute adjudicated which arises out of the contract, even if they have sold the property. If there is any balance amount to be paid by you to them, are they not entitled to receive it?
They have to disclose.
ಏನು?
As on.
ಬರೋದಿಲ್ಲ. Even if you bring a document which would show that they have sold the property, even otherwise, even if the contract is terminated, the law is that the arbitration clause will survive even after the termination of the contract to decide the disputes which have already arisen out of the contract. It will be treated as a different agreement.
Lessors are having dilated in this.
All that contentions you may raise before the arbitrator. Berkeley. First paragraph, second paragraph. The petitioners entered into a lease deed dated 7/7/2010 with the respondent company, wherein the respondent company became a lessee in respect of the scheduled property. Stop. Petitioner number 3 is a confirming party in the agreement. Stop. The petitioners terminated the lease deed by issuance of a notice dated 4/6/2022, at annexure B. Stop. The respondent herein caused a legal notice dated 24/12/2022 to the petitioners herein. Raising certain demands and grievances. So the respondent claimed a sum of rupees 8,26,40,196 as charges for use and occupation of a portion of the property, which was allegedly illegally retained by the petitioners. Full stop. The respondent invoked the arbitration clause contained in clause number 25 of the lease deed and nominated a retired district judge to arbitrate the matter. Full stop. The petitioners gave a reply dated 4/1/2022. It should be 23 alva. Huh? It should be 23. Bracket wrongly mentioned as 4/1/2022. Close bracket at annexure D. Not accepting the arbitrator suggested by the respondent, while nominating another retired district judge as an arbitrator on behalf of the petitioners here. Stop. Next para. Learned counsel for the petitioner submits that who filed section 9 application? The respondents filed a petition under section 9 invoking section 9 of the Arbitration and Conciliation Act 1996 for the commercial court. For the commercial court at Bengaluru. At Chamarajanagar. Full stop. During the course of the proceedings before the commercial court, an observation was made by the commercial court. Adike observation. Since there is an arbitration clause contained in the lease deed, the aggrieved parties have to seek appointment of an arbitrator. So, consequently, this civil miscellaneous petition has been filed by the petitioners seeking anyway. That has got nothing to do with section 9 petition.
Consequently, the same thing has been filed by the petitioner
Seeking appointment of a sole arbitrator in terms of clause 25 of the lease deed to resolve the disputes arising between the parties in the contract. Full stop. Next para. Learned counsel for the respondent. Learned counsel for the respondent, on the other hand, seeks to submit that the petitioners have sold the property in question in favor of a third party, and therefore they have they are only confirming parties. That company, Raj Safari is only a confirming party. Who is the actual owner of the property? Business Allah. Property was standing in whose name? Rudra Pratap Singh and Shruti Kirti. Then
counsel for the respondent, on the other hand, seeks to submit that the petitioner has sold the property in question in favor of the third party.
And therefore, the petitioners have no locus standi to file this civil miscellaneous petition invoking the arbitration clause contained in the lease deed dated 7/7/2010. Stop. ಇನ್ನೊಂದೇನೋ ಹೇಳ್ರಿ
became the directors of petition company. Because they filed the petition, they are not disclosed the same in the petition.
It is submitted that these relevant facts have not been stated by the petitioners in the petition. Stop. Next paragraph. Having heard the learned counsels for the petitioner, the learned counsel for the respondent, and on perusing the petition papers, this court finds that although an objection is sought to be raised at the hands of the respondents, that some third parties have been inducted into the third petitioner, Messrs. Raj Safari Private Limited, a company registered under the Companies Act. And the fact that the property has been sold to third parties is not disclosed in the petition. And for the same reason, since the petitioners are not any longer the owners of the scheduled property, they have no locus standi to invoke the arbitration clause contained in the lease deed. So, it is furthermore sought to be submitted that when admittedly the petitioners terminated the lease deed on 4/6/2022, the lease deed is no more in existence, and therefore the arbitration clause would not have been invoked by the petitioners. So, both these arguments cannot be accepted, since the law is well settled that even if a contract is terminated, the arbitration clause contained in the contract continues to be in existence to enable a resolution of the disputes that arose between the parties under the contract. So, reference may be had to the following decisions of the Honorable Supreme Court. On the other side, decisions like next paragraph. The other contention of the respondent that the petitioners have lost the title to the property in question, and therefore they have no locus standi to invoke the arbitration clause, is also not acceptable, for the reason that if disputes have arisen prior to the termination of the contract and the resolution of such disputes arise out of the contract, the petitioners will have all the rights to have the dispute resolved in terms of the arbitration clause. Stop. Even otherwise, all these contentions may be raised by the respondent before the arbitrator. Full stop. Next paragraph. For the foregoing reasons, this court is of the considered opinion that the petitioners have made out a case for appointment of an arbitrator in terms of the arbitration clause contained in the lease deed dated 7/7/2010 at Annexure A. Full stop. Next paragraph. You want a retired district judge? Is it? Who is it? You are claiming 8 crores and all. Huh? Then you let it go before a high court judge. ಗೊತ್ತಾಯ್ತು. Now if your claim is to an extent of 8 crores, let it go before High Court did. ಅವ್ರ ಮುಂದೆಲ್ಲ ಜಾಸ್ತಿ ಮ್ಯಾಟರ್ಗಳಿದ್ದಾರೆ. You will have to go and stand in queue. There are many other judges. Recently ರಿಟೈರ್ ಆಗಿರೋ ಜಸ್ಟಿಸ್ ವೀರಪ್ಪ ಅವರಿದ್ದಾರೆ, EN ದೇಸಾಯಿ ಅವರಿದ್ದಾರೆ, ಕೃಷ್ಣ ಭಟ್ ಅವರಿದ್ದಾರೆ. You can appoint any one of them. Honorable Justice B. Veerappa, former judge of this court.
Lordships, kindly, in serial number 10 and 11.
Ah.
But I have received instructions today morning to appear on behalf of the respondent. But I may be permitted to appear on behalf of respondent. Lordship may kindly grant me about 3 to 4 days time to get instructions. Next Tuesday or Thursday, Lordship may have.
Learned Counsel Sri T.P. Vivekananda undertakes to file wakalat for the respondent. Muda. Will stop. Release this matter on 12th of July.
13th, Your Lordship. 13th, Your Lordship.
Yalla, you are permitted to raise all objections. This is only an appointment of the arbitrator. In terms of the act itself, ಹೌದು, ಅವ್ರ ಕ್ಲೈಮ್ ಪಿಟಿಷನ್ ಮತ್ತೆ ಹಾಕ್ಬೇಕಲ್ಲಿ. They have to again file a claim petition. You will be permitted to file objection. Madi, you can also invoke. Berkeley. Since the respondent has also raised certain claims against the petitioners, the respondent is also permitted to raise a claim before the arbitrator. Ade raise a claim under other name. Yes.
It may be called on 13th minutes instead of 12th minute, 13th minutes.
13.
Please, oblige.
Lease deed. Clause 23. Issue notice to the respondent. Have the address. Learned counsel for the petitioner submits that the petitioner has collected the correct address of the respondent for service of notice. Will stop. A week's time is granted to the petitioners to take fresh steps for service of notice on the respondent. Yes. Hmm. No, we had asked you to find out whether the bylaws are registered or not. That information we want. If it's a registered association, you can get a certified copy of the bylaws. That is what we are asking for, not that you have to implement them. How will you produce it without taking a certified copy? Huh? On the previous occasion, this court had posed a question to the learned counsel for the petitioner as to whether the bylaws of the Regency Heights Association were registered or not. Stop. Learned counsel submits on instructions that the bylaws are registered. Stop. If that is the fact, then the petitioner is required to furnish a certified copy of the bylaws. Stop. Next para. 2 weeks time is granted at the request of the learned counsel for petitioner for furnishing the certified copy of the bylaws. Yes. Ah.
That is come back here. And is the correct
A week's time is granted at the request of learned counsel for petitioner for taking fresh steps for service of notice on the respondent.
During 2021 March, the rates stated for. So that not to, either petition not seeking for a common solution, not to find a way out of the rate market. 59 is that year. Also the 51 November is that part. The reason for the class not stable, two both opened up not to be compound. It's not the, which is bringing in the not the sewage water as well as the water to the lake. This one was not directed, not aware of the market and let us verify any large value or any enforcement. So survey was conducted, report was also filed. The report indicates not the over value.
What are you trying to say?
The report is filed.
ಅದೇ
ಅನುಭವ ತಾಲೂಕು ಅಂತ
ಏನು ಅಂದ್ರೆ ಹಾದು ಹೋಗುವ ಕಾಲುವೆ ಅಂದ್ರೆ ಅರ್ಥ ಏನು? ಕಾಲುವೆ ಈ ಲೇಔಟ್ ಅಲ್ಲಿ ಹಾದು ಹೋಗ್ತಾ ಇದೆ ಅಂತ. Whatever. When was the report filed?
This was done. The report does not take the entire layout.
Where is the report? Report of the Assistant Director of Land Records. Ah,
It is well.
yes. ಯಾವ ಪೇಜ್ ನಂಬರ್ ಓದ್ತಾ ಇದ್ರ ನೀವು? There are three communications. See, immediately after the affidavit, immediately after the affidavit, you will find a communication dated 13/12/2022 made by the ADLR to the learned HCGP or government advocate. That is the. Please read that one.
ನಿರ್ಮಾಣವಾಗಿರುವ ಸೈಟ್ ನಂಬರ್ 23 ರಚನೆ ಮಾಡಿ ನಿರ್ದೇಶನ
So and so right.
ಮಾಡಿ ವಿಷಯದೊಂದಿಗೆ ವರದಿ ಮಾಡಲು ಇನ್ನೊಂದು ಗಂಟೆಗೆ ಸ್ಥಳದಲ್ಲಿ ಹಾಜರಿದ್ದು ದಾವೇದಾರರ ಸಮಕ್ಷ ಹಿರಿಯ ಅಧಿಕಾರಿಗಳು ನೀರುಗಾವಲೆ ಅಧಿಕಾರಿಗಳು ಮತ್ತೆ ಈ ಕಚೇರಿಯ ಮುಖ್ಯಸ್ಥರು ಅಧೀಕ್ಷಕರೊಂದಿಗೆ ಸ್ಥಳಕ್ಕೆ ಹಾಜರಾಗಿ ಸ್ಥಳದ ಮೂಲ ಸರ್ವೆ ದಾಖಲಾತಿಗಳಿಗೆ ತಾಳೆ ನಕ್ಷೆಯೊಂದಿಗೆ
Yes.
ಸಪೋರ್ಟ್ ಮಾಡಿಸಿದ್ದಾರೆ. ವಿಷಯಕ್ಕೆ ಹಾಗೂ ಉಲ್ಲೇಖಿಸಿದಂತೆ ಆದಾಯದಲ್ಲಿ ಗ್ರಾಮ ಸರ್ವೆಗಳನ್ನು 14 ಹೆಕ್ಟೇರ್ಗಳಲ್ಲಿ ಹಾದು ಮುಗಿದ ನೀರುಗಾವಲೆ 2.4 ಮೀಟರ್ ಅಗಲದ ಕಾಲುವೆ ಬಫರ್ ಝೋನ್ನ ವರ್ಗೀಕರಣವನ್ನು ತಿಳಿಸಲು ಕೋರಿರುತ್ತದೆ. ಅದರಂತೆ ಆದಾಯದಲ್ಲಿ ಗ್ರಾಮ ಸರ್ವೆ ನಂಬರ್ 14 ಹಾದು ಮುಗಿದ ಕಾಲುವೆಯನ್ನು ಗ್ರಾಮ ನಕ್ಷೆಯಿಂದ ಪರಿಶೀಲಿಸಲಾಗಿದೆ. ಅದರಲ್ಲಿ ಸರ್ವಸಂಖ್ಯಗಳಲ್ಲಿ ಹಾದು ಮುಗಿದ ಈ ಭಾಗದ ಕಾಲುವೆಯನ್ನು ಫಿಶರಿ ಡ್ರೈನ್ ನೀರುಗಾವಲೆ ಎಂದು ವರ್ಗೀಕರಿಸಲಾಗಿದೆ. ಪ್ರಸ್ತುತ ಪಾಲಿಕೆಯಲ್ಲಿ ಚಾಲ್ತಿಯಲ್ಲಿರುವ ವಲಯ ನಿಯಮವಾದಂತೆ ಬದಲಿ ಮಳೆ ನೀರುಗಾವಲೆ ಸೇರಿದ ಕಾಲುವೆ ಎರಡು ಬದಿಯಲ್ಲಿ 15 ಮೀಟರ್ ಬಫರ್ ಜಾಗವನ್ನು ಕಾಯ್ದಿರಿಸುವುದು.
Yes. Now you please see the sketch.
It is sketch not they are trying to say the green one, the dotted. They say this is the buffer.
The center line is the drain.
Yes, drain.
Then they have marked the buffer zone.
Yes. Now they say not they are taking it 15 meters. And when you on the side to move up and to move up from the coming to the Washington and this is not the report rain water stream is not it is measuring 2.5 meters for measuring. And now not it had existed but now not they have opened up the holes that the rain water is coming that much. Well, buffer zone has been counted as 2015 not the CDP protocol. They have taken it as 15 meters from 15 meters also ahead 15 meters can be counted for the new drain. It should be counted for the CDP protocol. Coming to that point, meanwhile, what had happened was watching the candidate the business layout was in just to indicate why it came. Next step, you not on the photograph indicating not the rain what it caused, why it caused another case. It was the flood because caused.
Page number
155. 2009 is that we are deciding that. Sorry, 1999 we are deciding that. 155 in the north, these are all, and 1% died because they do not evacuate and patients from the layout. Subsequent to this, we have been regularly making representation to the authorities. Not what they do is not in 2000, not 2021.
Where is your layout plan?
Was a panchayat law. AV. A1, A2 and A2. A1, 24, 22. There was a minute panchayat. What has happened here? Again, lots opens up lots the main drain.
What's that plot number? Nura? In annexure A. Where are they? Eighteen and ಅದ್ ಹೆಂಗ್ರಿ ಬರೀ ಎರಡ್ ಸೆಟ್ ಆಗುತ್ತೆ. Please come to annexure A. You are appearing for who are the impeding? All right. Annexure A, please take annexure A. If there is a drain running. ದಯವಿಟ್ಟು annexure A ನೋಡಿ. 118, 119 ಅಲ್ಲೆಲ್ಲೋ ಮಧ್ಯದಲ್ಲಿ ಬರುತ್ತೆ. If a drain is running, can it affect only these two sides? Then your survey report is wrong. Then
Survey department is they are given the report. Based on survey report, I have tracked.
please see annexure A. See site number 118, 119. How can the drain only affect two sides? ಏನ್ ಯಾವ ತರ ರಿಪೋರ್ಟ್ ಕೊಡ್ತಾರೆ ಇವರು? What are they doing? Is it to help these residents or what? Sir, if there is a drain, first of all, it has to be cleared. We will come to the question of buffer zone later. You have to allow them to clear the drain firstly. Rainy monsoons have already commenced. If you go on making objections like this, we will ask them to come and demolish all the buildings there. There is a direction by the Honorable Division Bench. You can't cause obstructions like this. If there is a drain found, first of all, the drain has to be cleared. If there is any building on the drain itself, they have to go. There is no question at all. We will come to the question of buffer zone later. Yes.
Except you not have produced. This was not happening last till 21 November.
We are not concerned with that, sir.
I'm not on that.
We will not hear anything from you regarding shifting the drain. Adagadilla. We will not permit.
I am not asking to shift it.
Yes.
What is happening?
Yes.
Except,
Sir, drains have to be cleared.
definitely.
Yes.
I have 5% for the same purpose.
Hmm.
Lots of mechanics are there. I have what
So that can be done only after finding out the course of the drain. If a course of the drain is found, It has to be cleared.
ಈಗೇನಾಗಿದೆ? Why the lawsuit is unannexed.
Yes.
ಏನಾಗಿದೆ? Sajjapur road. They have brought the water from the behind and left on the front of the lane. ಇದನ್ನ outlet.
We are not concerned with that. We are only asking them to identify the then existing nala.
I'm not coming there. Let them.
We are only asking them to do that first. If it is identified and if it passes through the layout, first of all, you should allow them to clear the drain. There cannot be any other alternative for this.
ನಾನು ಕೇಳಿದ್ರು ಅದನ್ನ ಪಿಟಿಷನ್ ನಾನು ಕೇಳಿರೋದು ಈ ನೀರನ್ನ ಆಚೆ ತಗೊಂಡೋಗಿ ಏನಿಲ್ಲ ಅಂತ ಐ ಆಮ್ ನಾಟ್ ಸ್ಟಾರ್ಟಿಂಗ್ ಟು ಸ್ಟಾಪ್ ಸಜ್ಜಾಪುರ ರೋಡ್ ಅಲ್ಲಿ ಇಸ್ ದಿ ಮೇಜರ್ ರಾಜಕಾಲ ಹೋಗ್ತದೆ ಅದಕ್ಕೆ ಈ ನೀರನ್ನ ಕನೆಕ್ಟ್ ಮಾಡಿ ಅನ್ನೋದಕ್ಕೆ
ಅದೊಂದೇನ ಅದು ಫೈಲ್ ಮಾಡೋದು ಬೇರೆ ಏನಾದ್ರು ಫೈಲ್ ಮಾಡಿದಾರ ರಿಪೋರ್ಟ್. How is it possible that only two sides will be affected?
Lines ತೋರಿಸ್ತಾ ಇದೆ. It's not saying all, it's saying all that. They were 15 and 16. They are paid the government. In my petitions, my lords were pleased to directly Tahsildar to conduct the survey. They conducted the survey yesterday. They have also said there is a water channel of 2.4 meters. They have not yet issued the sketch, but they are basing this on the village map and some survey documents. Whereas in the CDP of 2015, there is no water channel.
There they may not show.
Please, even in the village map. Even in the village map, these survey numbers, there is no water channel at all.
It's a very small one that you have got now. Village maps will not be like this. They'll be huge and many details will be there in that. We can't go by this one.
This is the same map there.
No. We are not going to see this. Which is that other, you have filed another petition, is it?
That being disposed of. 19563 then the petitions were disposed of on 16/2/2023 and directed the Tahsildar to conduct the survey that they have conducted yesterday and answer was one of the sketch Marina. In the meanwhile, in this petition, the ADLR has been appointed to conduct the survey. Whereas in my humble submission, there is some difference in the directions that are given. Adರಲ್ಲಿ survey number 16 where the petitioners involved ಇಲ್ಲಿ ಈ matter ನಲ್ಲಿ you identify the starting and the ending of the drain ಅಂತ order ಆಗಿದೆ. What I just communicated from Nala petition is that they have tried to identify only in this 15 and 16 where the nala starts, where it ends, where it goes through has not been identified. And in the village map, whatever they are now showing, even in that what I just saw, is a small line that is shown, which is shown in the legend as Kalkar. There are natural gradients available, gradients in the land, and insofar as the
Which is that, please give a copy of that order.
of the
Not
order, they have filed along with the objections to my application, our application 16/2/2023. Learned friend has filed objections to my application.
You are also a resident of the same layout.
Yes,
Why are you objecting?
because whatever order may not may get passed here will affect me directly.
They are deciding on the upper grading. ತೊಂದರೆ ಆಗ್ತಿರೋದು ನಮ್ಗೆ. They are not, ಈ flooding ಅವರಿಗೆ ಯಾವ ತೊಂದರೆ ಆಗಿಲ್ಲ, ತುಂಗಾಗಿಲ್ಲ.
Then we support all the residents, we are not saying that they are, our grounds is, our interests are common.
Leave sort of India is.
The order in the previous writ petition and whatever directions this honorable court may issue this writ petition, they may have some impact upon my rights so far as.
Order on IA number 2 of 2023. This application. Who are the applicants? Who are the applicants?
The applicants are 15 scheduled.
Where have you stated? IA number 2 of 2023, isn't it? Who are the applicants?
Applicants are owners of different residential plots.
Where are they? Where are their names and addresses, sir?
In the main application, the
Where? Which page?
first page itself, all their names. 15 applicants. In Bansal and others. In Bansal, when you go in, Bansal. It is P. Vasudeva.
This is not the way the cost title has to be shown, sir. You have to show the actual cost title. And then down below that, you have to say proposed applicants. All of you are creating confusions like this. This application is filed by the impleading applicants seeking to implead themselves in the writ petition as party respondents to these proceedings. Stop. The writ petitioners are the residents of Rainbow Drive layout, which is situated at Halnaikanahalli, Vattur Hobli, Bangalore East Taluk. The applicants also are residents of the same layout. Stop. Learned Counsel for the applicants submits that the applicants herein had also filed a writ petition earlier in WP number
9563 573.
and the said writ petition was disposed of
2020.
while directing a survey to be conducted to identify the stormwater drain, and thereafter, after affording opportunity of hearing to the residents of the layout, action may be taken by the respondent authorities to clear the stormwater drain. Stop. Consequent to those orders, the survey was conducted and it is submitted that the report is getting ready. Stop. Learned Counsel for the impleading applicants would submit that the petitioners, being the residents of the layout, would be affected by any order that could be passed by this court in this writ petition, and therefore they are before this court. Full stop. Next para. Learned Counsel for the petitioner submits that it cannot be disputed that the impleading applicants are also residents of the same layout. Full stop. If that is the fact, then impleadment of the applicants will not cause any harm to the petitioners. Full stop. Next para. Consequently, the application is allowed. The impleading applicants are permitted to come on record as party respondents to these proceedings. Full stop. Next para. Learned Counsel for the petitioners shall carry out the amendment in the cost title and furnish amended cost title within a period of 1 week from today. Full stop. Next para. Who has conducted the inspection and huh?
In that case, it is the Tahsildar.
Tahsildar.
Today, India.
The Tahsildar is also party here.
This is
Next para. The second respondent, Tasildar, Bangalore East Taluk, Krishnarajapuram, who is stated to have made the survey in terms of the directions issued by this court in writ petition number
9563-2.7.
He is directed to submit the report before this court through the learned AGA. Stop. Release this matter on 12th of July. Report, let us see. Huh?
I have purchased property in the city of
You are appearing for the impleading applicant. Last time. ಅದೇ ತರ ಮಾಡಿದ್ರಿ ಇವಾಗ ಏನ್ ಹೇಳ್ದ ಅವ್ರಿಗೆ you have submitted a fresh application.
Point number 2. Application and respondent number 2 are stating that they are co-owners of the property.
Co-owner.
Co-owners.
Ah.
So respondent number 2 is already appearing to same advocate. Now there is one more application saying that he has failed. Whatever application he has failed. Respondent number 2 is already represented.
That's all right. But if this person also is a co-owner, then he should have naturally been made a party here. Even otherwise, if you did not know, and if he is now saying that he is also a co-owner, any order that passed here would affect his rights. Is he not a necessary party? Let him come on record. What is there?
Adam heard Adam not changed in many. So past only I have paid for contact to pay. So in option purchase, I am not able to even avail loan for the development of this property.
Yes.
That is the essence.
Order on IA number 3 of 2023. The application is filed by the impleading applicant to seek to come on record as a party respondent to these proceedings. It is contended that along with respondent number 2, the impleading applicant also is the co-owner of the property in question. Stop. Therefore, he becomes a necessary party to these proceedings. Stop. Accepting the submission of the learned counsel for the impleading applicant, IA number 3 of 2023 is allowed. Learned counsel for the petitioner shall carry out the amendment in the cost title and furnish amended cost title within a period of 1 week from today. Full stop. Yes, you can make submissions on this.
Actually, 8 page 11.
Ah.
I have purchased the property and actually keep page 45 to say that it is registered.
45.
Page 45. But on 18/2/2022, under certificate proceeding, this property came to be off and I purchased this property. After purchasing the property, I filed application for transfer of title to respondent number 1. But in the meantime, the respondent number 2 had filed petition for they are the borrower. G and G1, page 45 and G.
Sales certificate dated 18/2/2022.
And G1.
There are two
properties.
Ah.
I have filed application seeking for transfer of to respondent number 1. Number respondent number 2 had filed objection there.
saying that he had already filed two requisitions before this court, challenging the surface action, and that is pending for this court, and others have not been done. On that basis, an endorsement is true that it is not not transferred in my favor. Third, in those two requisitions, subject to condition of 30% payment, third stay was granted. Third, he has not paid any amount. Because of that reason, the respondent of the bank has executed sales certificate and has also registered as a bank. As per the registered document, I am seeking for transfer of Khata. That petition is kept pending and past 1.5 years, Khata is not transferred in May. I said, the only reason is that two petitions are pending. WP number 2402 of 2022 and the guideline of 11. And those writ petition on the page 26 annexure C.
The stay order in those writ petitions continue.
No, because subject to condition that he pays.
So they didn't pay. There is no condition. Yes.
Regarding this. It's been pending in the. Suppressing that, the appeal is pending because the tribunal at Chennai.
So you have withdrawn the writ petition.
Not withdrawn.
How can you pursue remedies in two forums?
Not in the appellate tribunal.
Including application for that they have filed application for DRA. That is dismissed, they have filed appeal for the DRA.
All right. Is there any order of stay granted by the DRAT? See, all that will happen is that they will transfer the Khata. As and when you succeed, if the sale made in favor of the petitioner is set aside, Khata also will go. How can you object for transfer of Khata? That's all right, sir. There is a sale deed executed. Now it a question of only transfer of Khata. Transfer of Khata has what efficacy? It is only to identify who is going to pay the taxes. Therefore, as and when you succeed, if there is an order of stay, you please pass it on. Otherwise, you await the outcome of the appeal. If you succeed and the sale deed is set aside, naturally the Khata also will go. No. No.
Regarding
No, sir. You should have furnished a copy of the stay order if it was there. No. You are there already on record for respond number 2, sir. Are you not the learned counsel for respond number 2? Then what is your answer for that? The writ petitioner having purchased the lands in question in a public auction conducted by the third respondent, Tumkuru Grain Merchants Cooperative Bank Limited, is before this court aggrieved by the impugned endorsement dated 6/6/2022 at annexure A, given by the Commissioner of the City Municipal Council. City Municipal Council, Kootagalli, Mysore district. Stop. Next para. The petitioner, learned counsel for petitioner, draws the attention of this court to annexures G and G1, which are the sale certificates registered before the jurisdictional sub-registrar on 18th of February 2022. Stop. Learned Counsel submits that the petitioner, having participated in the public auction and having been declared as the successful bidder, paid the bid amount, and after fulfillment of all the conditions, the sale was confirmed and sale certificates were issued in favor of the petitioner. Stop. The second respondent and the newly implemented respondent number 4 claim to be the previous owners of the property. Stop. They have sought to raise an objection before the commissioner of the CMC for the application made by the petitioner seeking transfer of kata. Stop. Respondent number 2 and respondent number 4 brought to the notice of the commissioner that they had filed writ petitions number 2402 of 2022 and 8159 of 2022, and since the matters were pending considerations, the kata should not be transferred in favor of the petitioner. Stop. Accepting the contentions of response number 2 and 4 herein, the impugned endorsement has been issued by the commissioner. Full stop. Next para. During the course of these proceedings, Learned Counsel for response number 2 and 4 submits that you had not filed writ petitions. You had not filed writ petitions. You had filed. Submits that respondents number 2 and 4 have also approached the Debts Recovery Appellate Tribunal at Chennai, calling in question the orders passed by the Debts Recovery Tribunal. Stop. It is therefore sought to be contended that since appeals have been preferred before the Debts Recovery Appellate Tribunal, the katas should not be transferred in favor of the petitioner. Stop. Next para. Having heard the learned counsels and on perusing the petition papers, this court finds that the petitioner has got the sale certificate executed at the hands of the third respondent bank. Stop. In terms of the registered instrument, the title having passed on to the petitioner, the petitioner is entitled to have the kata registered in his name in the office of the respondent CMC. Stop. Admittedly, there is no order of stay passed by this court or this court in the writ petitions that were earlier filed by the response number 2 and 4, nor by the appellate tribunal at Chennai. Stop. Therefore, respondents number 2 and 4 cannot cause an obstruction to the application filed by the petitioner for transfer of kata. Stop. On the other hand, if respondents number 2 and 4 succeed before the appellate tribunal and the sale certificates issued in favor of the petitioner is set aside by any court of law or tribunal, respondents number 2 and 4 will be entitled to seek cancellation of the Khata and have their names re-entered in the Khata register. We'll stop. Next paragraph. For the reason stated above, this court is of the considered opinion that the impugned endorsement dated 6/6/2022 at Annexure A issued by the Commissioner, CMC, Hootagalli, cannot be sustained. We stop. Next paragraph. Consequently, the repetition is allowed. The impugned endorsement dated 6/6/2022 at Annexure A is hereby quashed and set aside. Full stop. A direction is issued to the Commissioner, CMC, Hootagalli to pass necessary orders on the application filed by the petitioners for transfer of Khata on the strength of the registered sales certificates at Annexures G and G1. Full stop. The entire exercise shall be completed as expeditiously as possible and at any rate within a period of 2 months from the date of receipt of a copy of this order. Full stop. Ordered accordingly.
The help of Kata is not create any excessive liability on the property. In the event he creates a 10 crore rupees liability on the property.
We have to get an order from there. No order can be passed. We are only concerned with the Khata. All other aspects you will have to get a order, interim orders. Yes.
3 months.
2 ತಿಂಗಳೇ ಜಾಸ್ತಿ ಆಯ್ತು. Yes.
Existing nala in the and question 62/4.
Yes. You had alleged that at the instance of some other parties, they are trying to divert the nala. Yes. Yes.
The corporation to divert the plan. Even otherwise, if they wanted to set up such a train, after existing nala, after the diagnosis, after the survey, we document.
One document.
You are appearing for whom? ಏನ್ ಅಬ್ಜೆಕ್ಷನ್? ನಿಮ್ದೇನ್ ಅಬ್ಜೆಕ್ಷನ್ ಇರುತ್ತೆ? We are only concerned with the nala.
And this is only, and he has not included the other persons who have been. Uttama is not one of the bank owner.
ಏನಕ್ಕೆ? For what purpose? ಏನು ಬೇಕಾಗಿಲ್ಲ. There is nothing in this. Barkali. All right. We are not deciding any title in this writ petition. He says he is the owner of the property, and they are now trying to divert the nala into his property, contrary to the earlier existence of the nala. We are not deciding that one. We are only concerned with the allegation regarding diversion of the nala. Ashte. We are not concerned with that. At your instance, if they are trying to divert the nala, then
ಅದನ್ನ ಡೆವಲಪ್ಮೆಂಟ್ ಮಾಡಿದ್ದು ನಾಲ ಮಾಡಿದ್ದಾರೆ. ಅದನ್ನ ಫೋಟೋ ಹಾಕಿದ್ದೀವಿ. ಅದನ್ನ ಕೇಸ್ they register nala nearly about 30 years back. Nobody enforced. Even my land 7 acres has been washed away in the rain, and it has marked as a nala. So that I am not claiming any compensation from them. For that sake, only I put the photograph to show that
we are not deciding the rights of the parties or the title of the parties. We are only concerned with the allegation made by the petitioner that they are now trying to divert the nala. And we had asked the learned counsel for the BBMP as to whether there is any plan to divert the existing nala. He is saying on instructions that no such plan is there to divert the nala. If a nala is already existing, let it continue. And if there is any objection raised regarding the existence of the nala, that's a different matter.
As per the, I have taken as per the Kodiwala committee, in the Madhepura and Bendiga and other surrounding areas, there is a large extent of floods in the.
PAL.
I am
Go
not.
file a PAL.
PL, wherein a master revision plan and as per the. PDA.
ಅದನ್ನೇ ಹೇಳ್ತಾ ಇರೋದು.
So
All these contentions cannot be raised at your hands.
survey-
We are here in this writ petition, we are concerned only with your property. So if you are raising all the other contentions, it would take the nature of a public interest litigation. Please go there. Perfect. We are not deciding the rights of the parties. Sir, he is not making any allegations regarding encroachment of the property. He is only alleging that at the instance of some parties, the BBMP is now trying to divert the nala into his property. Ashte. Huh? Then
My case is, the defendants contesting respondents who are their respondents seven to private respondents. They have diverted the nala and they are now using the layout, entire layout, and they want to sell the property. They are admitted back by the BDA, by the the BDA and BBMP authorities for conversion, they applied for conversion of their land. Wherein the authorities have declared as observed that the subject matter of their land, seventh respondent who are the private respondents, so the 62 are private, 62% there already existence of nala. Therefore, as per the buffer zone rules, we are giving permission to convert this land. The existence of nala has been admitted by the authorities.
Sorry.
Now,
Fine.
as per the revised master plan 2015 drainage is a small 15 meters, 25 meters, and 50 meters. There are three types of drainage, sir.
Yes.
As per- Here, they have closed that and they are using that as a layout and they are selling the property. That the diversion in of the closing, the existing area old nala has been closed. And it was diverted by adjacent land. I am the adjacent owner of the property for 1 day. I am the rightful owner. My Tata is in our name. There is a that now in of the floods not that nala was not as demolished. And these people have been diverted that nala in their exactly responding 14 respondents who are their private respondents. In the middle of the they are claiming to be the owners of that property. In that the middle of the portion survey which demonstrates that there is a existence of nala. They are closed now. That's therefore I filed an application before all the BBMP authorities, town planning and other, they closed the nala and using that. In the while giving a representation, they have declined to consider my representation.
What is your grievance?
Grievance is they are closed and diverted and selling the property.
Huh.
It's the nala.
How are you affected?
Now, in view of the closing, that the 62/6 the nala has been now bifurcated, they have diverted. it.
ಅದನ್ನೇ ನಾನು ಹೇಳ್ತಾ ಇರೋದು. That is what I said. ನೀವೆಲ್ಲ ಸುತ್ತಿ ಬಳಸಿ ಮತ್ತೆ ಅಲ್ಲಿಗೆ ಬರ್ತಾ ಇದ್ದೀರಾ. And you are saying no, I didn't say they are trying to divert.
Already
What
they
is this?
closed the nala. That is my.
They are diverting the nala into your property.
Yes, madam.
That is the allegation, isn't it? ಅದನ್ನೇ ಮತ್ತೆ ನಾವು ಕೇಳಿದ್ದು.
How will I what they are saying?
They are saying, ಹೌದು,
But already closed, nala has been closed.
ಅಲ್ಲಿ ಕ್ಲೋಸ್ ಆಗಿರೋದು ನಿಜ ಇರ್ಬೋದು, ನಿಮ್ಮ ಅಲಿಗೇಷನ್ ಕರೆಕ್ಟ್ ಇರ್ಬೋದು. But your ultimate prayer is that to ensure that the nala is not diverted into your property. ಅಷ್ಟೇ ತಾನೆ?
ನಾನು divert ಮಾಡೋದು ಬೇಡ, close ಮಾಡಿ ಬಂದಿರೋದನ್ನ ಮಾಡಬಾರ್ದು my deviance is.
That then it becomes a public interest litigation. Then your apprehension is that they have closed down the nala and now they are trying to divert that into my property.
My property.
Alva? Ultimately, it will come to that only. Otherwise, it will become a public interest litigation. If your allegation is not that they are now trying to divert the nala into my property, There is no other cause of action for you. Your cause of action does not arise because they have closed down the nala.
Therefore,
If they have closed down the nala in their property and the water is now being diverted into your property, your grievance will only be in respect of the diversion of the nala into your property or the water coming into your property.
you have diversion. You have diversion. What is going in my property now? Therefore, take an appropriate action to say, conduct a survey. The closing has been reopened as earlier existence. That is my grievance. That's why I filed an application before the authorities.
Odi, please read what is your prayer
Prayer mechanism.
in the representation.
Representation. Annexure A.
Yes.
Page number 17 may kind of.
Yes.
Last 3 paragraph may I read?
Yes.
ಈ ಜಮೀನಿನ ಮಾಲೀಕ ರೆಡ್ಡಿ ಅವರು ಪ್ರಧಾನವಾಗಿ ಇವರ ಜಮೀನಿನಲ್ಲಿ ನೀರು ಹರಿಯುವ ರಾಜಕಾಲುವೆ ಉಪಕಾಲುವೆಗಳು ಮರವೆ ಹಳ್ಳಿಗಳನ್ನು ಕಬಳಿಸಿಕೊಂಡು ಅವರ ಜಮೀನನ್ನು ವಿಸ್ತೀರ್ಣ ಮಾಡಿದ್ದಾರೆ. ರಾಜಕಾಲುವೆಗಳಿಗೆ ಬಿಡಬೇಕಾದ ಬಫರ್ ವಲಯದ ನಿಯಮಗಳನ್ನು ಪಾಲಿಸಲಿಲ್ಲ, ಗಾಡಿಗೆ ತುಂಬಿದ್ದಾರೆ. ಈ ಪ್ರತಿ ಜಮೀನುಗಳು ಬಹುಮಹಡಿಯ ಕಟ್ಟಡ ಯಾವುದೇ ಪ್ಲಾನ್ ಅಭಿವೃದ್ಧಿ ಮಾಡಬಾರದು. ನನ್ನ ಪ್ರಾರ್ಥನೆಯನ್ನು ಪರಿಶೀಲಿಸಿ ರಾಜಕಾಲುವೆಯನ್ನು ಮಾನ್ಯ ಮುಖ್ಯಮಂತ್ರಿಗಳ ಆದೇಶದಂತೆ ನಿಖರವಾಗಿ ಅಳತೆ ಮಾಡಬೇಕೆಂದು ಮತ್ತು ಮೇಲೆ ತಿಳಿಸಿರುವ ಅಂಶಗಳನ್ನು ಪರಿಶೀಲಿಸಬೇಕೆಂದು ನಾನು ಸರ್ಕಾರದಿಂದ ನಿವೃತ್ತಿಯಾದ ಮಾಡಬೇಕು ಅಂತ ರಿಕ್ವೆಸ್ಟ್ ಮಾಡ್ಕೊಂಡಿದ್ದೀನಿ.
Elri, where is the allegation that the water is now flowing into your land?
In para number say 17 to the same page. Second paragraph onwards.
Yes.
ಸದರಿ ಈ ಮೇಲ್ಕಂಡ ವಿಲಾಸ ವಾಸಿಗಳಾದ ನಾವು ನಮ್ಮಲ್ಲಿ ವಿನಂತಿಸುತ್ತೇವೆ. ಇಕೋ ವಿಲಾಸದಲ್ಲಿ ಕಗ್ಗದಾಸಪುರದ ಸಭೆಯನ್ನು 1ನೇ ಮುಖ್ಯಸ್ಥ ಸಿರಿನ ರೆಡ್ಡಿ ದೊಡ್ಡಗುರಪ್ಪ ಮತ್ತು ಅನಂತಮೂರ್ತ ರೆಡ್ಡಿ ಕಾವೇರಪ್ಪ ಅವರಿಗೆ ಸೇರಿದ ಜಮೀನು ಸರ್ವೆ ನಂಬರ್ 62/23 67/4 5/6 ಎನ್ನಿಗಾರಲ್ಲಿ ಡಾಕ್ಟರ್ ಏನಾರಾಯಣಪುರ ಮೈಲೇಔಟ್ ಹೊಂದಿರುತ್ತದೆ. ಸದರಿ ಜಮೀನಿನ ಮಧ್ಯದಲ್ಲಿ ಹರಿದಿರುವ ಮುಖ್ಯ ರಾಜಕಾಲುವೆಯನ್ನು ಅಕ್ರಮದಿಂದ ಅದರ ಮಾರ್ಗ ದಿಕ್ಕು ಅಳತೆ ಬದಲಾವಣೆ ಮಾಡಿ ನನ್ನ ಸ್ವಂತ ಚಿಕ್ಕ ಜಮೀನಾದ ಸರ್ವೆ ನಂಬರ್ 62/1 ಮತ್ತು 62/2 ಪಕ್ಕ ಹರಿಯುವ ಹಾಗೆ ಮಾಡಿದ್ದಾರೆ. ಇದರ ಬಗ್ಗೆ ಅನೇಕ ದೂರುಗಳನ್ನು ನೀಡಿದ್ರು. ಪ್ರಯೋಜನವಾಗದೆ ಮಾನ್ಯ ಮುಖ್ಯಮಂತ್ರಿಗಳಿಗೆ ಮನವಿ ಮಾಡಿ ಅದರ ಪತ್ರದಂತೆ ಪ್ರಕಾರ ಈ ಸದರಿ ರಾಜಕಾಲುವೆ ಕಲ್ಪಿಸಲು ಆದೇಶ ನೀಡಿದ್ದಾರೆ. Now, their documents, survey records and clearly indicated page number 25, middle of their portion will not be existing ರಾಜಕಾಲುವೆ. ಅದೇ ಪ್ರಕಾರ ಅವರು ಕನ್ವರ್ಷನ್ ಅಪ್ಲೈ ಮಾಡ್ತಾರೆ. Where in the conversion order also the authorities have come to a conclusion that in the middle of survey number 62/6 there is a national outline nale government records nale middle of the land in national ide anta heli ಕೊಟ್ಟಿದ್ದಾರೆ.
ಹಂಗಿದ್ರೆ while sanctioning the plan
subject to condition ಮಾಡಬೇಕು. ಬಫರ್ ಝೋನ್ ನಿಯಮಗಳನ್ನು
ಹಂಗ ಬಿಡ್ಲೇಬೇಕಲ್ಲ ಅವರು. Where is the question of closing it down?
they have closed.
ಹೆಂಗೆ sir? How is it possible, sir? When you are saying that has been noticed in the order of conversion and they are required to leave the buffer zone, how can they put up construction contrary to that?
ಅದನ್ನು ಕ್ಲೋಸ್ ಮಾಡಿರೋದಕ್ಕೆ ಪೇಜ್ ನಂಬರ್ 68 ಮೇಲೆ ನೀವು
property. He paid a suit against me and the suit has been dismissed.
That is not
I will get a judgment copy of the
ಏನು page number?
Page number 68 of the objection statement. They have refused the conversion conditions and the authorities.
ಯಾರು ಹಾಕಿರೋದು objection?
6.7 to 14.
ಕೊಡಿ.
Page 68. The letter, the order allowed as issued by the Bangalore Development Authority. Page 68 may annexure R3. Second paragraph I may be completed to read.
Yes.
ಸರ್ಕಾರದಿಂದ ದಿನಾಂಕ 25/6/2007 ಅನುಮೋದನೆಗೊಂಡಿರುವ RMP ರಿವೈಸ್ಡ್ ಮಾಸ್ಟರ್ ಪ್ಲಾನ್ 2015 ಅಂತೆ ಬೆಂಗಳೂರು ಪೂರ್ವ ತಾಲೂಕು ಮಹದೇವಪುರ ಹೋಬಳಿ ಬೆನಿಗಾನಹಳ್ಳಿ ಗ್ರಾಮ ಸರ್ವೆ ನಂಬರ್ 62/6 ರಲ್ಲಿ 21 ಗುಂಟೆ ಮತ್ತು ಸರ್ವೆ ನಂಬರ್ 62/5 ರಲ್ಲಿ 20 ಗುಂಟೆ ವಿಸ್ತೀರ್ಣ ಪ್ರದೇಶವು ವಸತಿ ವಲಯಕ್ಕಾಗಿ ವರ್ಗೀಕರಿಸಿದೆ ಹಾಗೂ ಆನ್ಲೈನ್ ನಲ್ಲಿ ನಕ್ಷೆ ಸಲ್ಲಿಸಲಾಗಿರುವ ಸರ್ವೆ ನಕ್ಷೆಯಲ್ಲಿ ನಾಲಾ ಹಾದು ಹೋಗಿರುತ್ತದೆ. ಆದ್ದರಿಂದ ಸದರಿ ನಾಳೆಗೆ ಅಗತ್ಯ ಬಫರ್ ಕಾಯ್ದೆಯಿಸುವ ಷರತ್ತುಗಳನ್ನು ಒಳಪಡಿಸಿ ಆನ್ಲೈನ್ ನಲ್ಲಿ ಸಲ್ಲಿಸಿರುವ ಪ್ರಮಾಣ ಪತ್ರ ಮತ್ತು ಸರ್ವೇನಕ್ಕೆ ಆಧರಿಸಿಕೊಂಡು ಈ ಕೆಳಕಂಡ ಷರತ್ತುಗಳಿಗೆ ಒಳಪಡಿಸಿ ಹಾಲಿ ಸಾರ್ವಜನಿಕ ರಸ್ತೆ ಸಂಪರ್ಕ ಇದ್ದಲ್ಲಿ ಮಾತ್ರ ವಸತಿ ಉದ್ದೇಶಕ್ಕಾಗಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ. ಸೆಕೆಂಡ್ ಕಂಡೀಷನ್ ಪ್ರಸ್ತಾಪಿತ ಪ್ರದೇಶವು ಕೆರೆಗೆ ಅಥವಾ ನಾಲೆಗೆ ಲಗತ್ತಾಗಿದ್ದರೆ ಅಥವಾ ಪ್ರಸ್ತುತ ಜಮೀನಲ್ಲಿ ಕೆರೆ ನಾಲ ಹಾದು ಹೋಗಿದ್ದಲ್ಲಿ ಸದರಿ ಕೆರೆ ನಾಲದ ಅಂಚಿನಿಂದ ಅಳವಡಿಸಬೇಕಾದ ಬಫರ್ ಝೋನ್ ನೋ ಡೆವಲಪ್ಮೆಂಟ್ ಭಾಗವನ್ನು ಕಾಯ್ದೆಯಿಸುವುದು. ನಾವು ಮಾಸ್ಟರ್ ಪ್ಲಾನ್ 2015 ರಿವೈಸ್ಡ್ ಅವರು ಇದೇ ಸರ್ವೆ ನಂಬರ್ 16 ನಲ್ಲಿ ನಾಲ ಹೋಗಿದೆ ಅಂತ ಅಡ್ಮಿಟೆಡ್ ಸ್ಕೆಚ್ ನಲ್ಲೇ ಇದೆ. our conditions they have been given in as per the master plan revision plan guide the existing nala nalli irbekagide buffer zone rules. The drains guard has been categorized into 3 types, namely primary, secondary and tertiary. These drains will have been buffer of 50 and 25 and 15 meters measured from the center of the drain. Even that also taken into consideration, they have violated. Admittedly, the photographs clearly demonstrate that in the middle of the portion, when there is an existence of nala.
What is this document you read out now?
They have given an application for conversion of the land to the deputy commissioner. Deputy commissioner Milan has forwarded that they have to get the NOCs from the Bangalore Development Authority and other competitive authorities, where the Bangalore Development Authority has issued based on their representation. This RMA revised master plan.
After this communication, where is the conversion order?
The conversion order Milan is there, survey sale deed nalli ಅವರು ಮೆನ್ಷನ್ ಮಾಡಿದ್ದಾರೆ.
Conversion order copy already.
You lost me look at the page.
Where is the conversion order copy?
Annexure R3 page 89.
R3 is 80. Other document ನೀವು ಓದಿದ್ದು.
ನಾನು ಓದಿದ್ದು DDA has issued an
That is annexure R3.
that is
Where is the conversion order?
conversion order. So they have this.
ಕೊಡಿ.
89. ಹನ್ನೆರಡು ಐದು 2020 ಕನ್ವರ್ಷನ್ ಆಗಿ ಇದರಲ್ಲಿ ಅಷ್ಟೇ ಜಮೀನು ಮಾಸ್ಟರ್ ಪ್ಲಾನ್ ಆಧಾರಿತ ಗ್ರೀನ್ ಪರಿವರ್ತನೆಗೆ ಒಳಪಡಿಸತಕ್ಕಂಥ ಬಗ್ಗೆ ಹೇಳಿದೆ ಸ್ಟ್ಯಾಂಡರ್ಡ್ ಕನ್ವರ್ಟೆಡ್. ಇದರಲ್ಲಿ ಆಸ್ ಪರ್ ಬೇಸ್ ಪ್ಲಾನ್ ವಿಲ್ ನಾಟ್ ಆಲ್ಸೋ BDA first one you will kindly see in the first document. BDA ಯೋಜನಾ ಪ್ರಾಧಿಕಾರ ನಿರಾಕರ್ಷಣಾ ಪತ್ರ NOC ತಗೊಂಡಿದ್ದಾರೆ. ಆ NOC ನಲ್ಲಿ this by what I read before this on NOC ನಲ್ಲಿ middle of the portion ಇದೆ. You have to follow the buffer rules and thereafter conversion has to be done. Conversion of follow ಮಾಡಿಲ್ಲ, close ಮಾಡಿದ್ದಾರೆ. Like BSC before the court, they have closed the entire land and they have not left out the buffer zone conditions. They have not followed. Authorities have declined to take an action. Therefore, I approached this honorable court. From 2000, I have given a 10 representations to all the authorities. Admitted survey records brings a meet the existence of Rajkalway.
ಹಾಗೆ ಇದೆ 30 ವರ್ಷದಿಂದ ಇದೇ ಮಾಡಿ
1991 or 1991.
How is it that what was noticed in the BDA communication is not reflected in the conversion order?
Only they have mentioned BDA NOC ಇದೆ ಅಂತ ಹೇಳಿ they have closed.
ಹಂಗಾಗೋದಿಲ್ಲ. The Deputy Commissioner, while seeking the NOC from BDA, Planning Authority, had told them that there is an existing nala and what is the buffer zone that has to be left. ಅಂತ ಕೇಳೋದಕ್ಕೋಸ್ಕರ ಅವ್ರಿಗೆ ಕಮ್ಯುನಿಕೇಟ್ ಮಾಡಿದ್ದು. How is it that in the conversion order the existence of the nala is not noticed?
That is the hand in go. The authorities have closed that issue and issued this conversion.
And where is the sanctioned plan? Where is the sanction plan? Huh?
ಲೆವೆಲಿಂಗ್ ಆಗಿದೆ, ಕನ್ವರ್ಷನ್ ಆಗಿದೆ, ಟೆಕ್ನಿಕ್ ಪ್ಲಾನ್ ಆಗಿದೆ, ಲೆವೆಲಿಂಗ್ ಆಗಿದೆ, ಕನ್ವರ್ಷನ್.
You have not approached the planning authority? Huh?
Yesterday, conversion.
12/5/2023. But ಅಲ್ಲ ಅದರಲ್ಲಿ ಹೇಳಿದಾರಲ್ಲ, you will have to go before the planning authority to seek the sanction. What are you proposing to put up here?
They want to have a residential layout.
Residential layout. Then you will have to approach the BDA.
Yes, certainly we have to. We have to approach.
And,
R1 ನೋಡಿ, suit he has filed a claim in main property 3 hectares.
Sir, we are not on the. No. Now,
Photo produce
which allegation is that you are closing down the nala which was running in the property. Because of you are closing down of the nala, the water is now entering into his property. That is the allegation.
Yes, sir.
If that is correct, then action will have to be.
ಅದಕ್ಕೋಸ್ಕರ ನಾನು ಫೋಟೋ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದೀನಿ. ನಾಳೆ ಆಗಿದೆ, ಹಾಗೆ ಹೋಗ್ತಾ ಇದೆ ಅಂತ ನಾನು ಅಬ್ಸರ್ವೇಷನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಲ್ಲಿ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದೀನಿ. ನಾಳೆ
ಇದು you have only taken the photograph of the drain ಅಷ್ಟೇ. You are not showing whether this draining is running within the property of yours, or is it at the edge of your property, or what is it? Because there is an observation in the communication made by the Bangalore Development Authority that you yourself have said that there is a nala running in the property. If the nala is running, then they'll have to leave so much of buffer zone.
Yes, sir, you have to do it.
And now you are saying, no, there is no such nala at all.
ಅಲ್ಲ ನಾಳೆ ಅಂತ ಏನು ಕವರ್ ವೆಟ್ಲ್ಯಾಂಡ್ ಈ ಹೋಗುತ್ತೆ, ಅದನ್ನ ಸಬ್ಸಿಕ್ವೆಂಟ್ ಇಯರ್ 1991 ಇದು ಅಗ್ರಿಕಲ್ಚರ್ ಆಪರೇಷನ್ ಕ್ಲೋಸ್ ಆಗುತ್ತೆ. ಆ ಬಂದ್ ನೀರು ಬೌಂಡ್ರಿ ಗೇಟ್ಸ್ ಹೋಗೋದಕ್ಕೆ ಅವ್ರು ನಾಲ ಮಾಡಿ, ಆ ನಾಲೆನೇ ಇದೆ. ಅದು ನಾನು ಫೋಟೋ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ 1991. there is only the nala is there, not other. ನಂದೇ ಲ್ಯಾಂಡ್ 7 ಗುಂಟೆ ಹೋಗಿದೆ ಇಲ್ಲಿ, ಮಳೆ ಬಂದು ಕೊಚ್ಕೊಂಡು ನಂದು 21 ಗುಂಟೆ ಲ್ಯಾಂಡ್ ಇರ್ಬೇಕಾಗುತ್ತೆ, ಇರೋದ ನಂದು 14 ಗುಂಟೆ. ಅದಕ್ಕೋಸ್ಕರ we want to show that this nala is not a present nala. 1991 when the nala that has been created, as it is still there,
Some of starting of their land, they are closer to the nala.
What have you stated in your objections after obtaining the conversion order? What have you done? ನಿಮ್ಮ objection ಅಲ್ಲಿ please read what have you stated. After obtaining the conversion order, what have you done? ಯಾವ paragraph?
Paragraph 6.
Paragraph 6.
Page 4.
Yes.
Paragraph 6.
Yes.
The purchaser has stated above, has not converted the said land, copy of the order of conversion produced. Cannot make BDA, we competent authority as party in the above decision. We did the same process one. Respondent what is have denied all those things.
They are treated, they are being developed by the state 21 hectares. 3 lanes of.
21 guntas ali, I don't think they will be asking for a plan to form a layout. Layout baralla, probably they are putting up a residential apartment.
Survey numbers there, we are not.
21 guntas ali, you can only put up 14 guntas. 14 guntas ali, probably you will be putting up a residential apartment or commercial apartment, whatever, commercial complex. Conversion is for what?
Residential layout. Mass documentation currently. As per our. If I not page number, they himself will be very same sketch. Availability. In the sketch also, we will not, in the middle of their survey number, will not.
Residential layout. ಅದೇನ್ರಿ ಅದೇನ್ ಕರೆಕ್ಟ್ ಆಗಿ ನೋಡ್ಕೊಂಡು ತಾನೇ ಅವರು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕ್ಬೇಕಾಗಿತ್ತು. 21 ಗುಂಟೆಯಲ್ಲಿ ನೀವು ಲೇಔಟ್ ಫಾರ್ಮ್ ಮಾಡ್ತೀರಾ? You are not the owner.
I am the owner of the land. I intend to memorandum of understanding with the 5 to 13.
Guru.
Yes, sir.
What
I am certificating for you. That in the existing area that I will photo you. You go in between the 16 survey of total 62. It is really about 9 acres and that. We have only 21 guntas. Out of which you 7 guntas has gone to the Nala. Because the rainy season is only.
Then why did you get it converted to 21 guntas? Already conversion order notri. You nim statement of objection ಅಲ್ಲಿ exclude ಮಾಡೋದಲ್ಲ. Why did you have to pay a conversion fee for conversion of 6 guntas or 7 guntas additionally? If your contention is that there are only 14 guntas. I made it clear whether it's a residential apartment. What is the plan? What are you planning to do? Layout ಅಂತ ಹಾಕಿದ್ದಾರೆ.
They have sites, individual sites are what is they are selling, sir. For residential layout, there is a purpose we do it.
Layout residential ಅಂತಾನೆ ಹಾಕಿರೋದು ಕನ್ವರ್ಷನ್ ಆರ್ಡರ್.
Sites.
The prayer in the repetition is issue directions to respondents number 1 to 4 consider the representations dated 22/8/2020 and 4/11/2022. Given by the petitioner and to take appropriate legal action against response number 5 to 13 regarding the closing down of the existing Rajakalve in old survey number 62/4 of Benniganahalli village, KR-Puram Hobli, Bangalore East Taluk. So, next para. It is the contention of the petitioner that respondents number 5 to 13 herein have closed down an existing Rajakalve, and as a consequence of which the storm water that was earlier flowing in the Nala has been now diverted into his property. Stop. It is contended that the contesting respondent had approached the deputy commissioner seeking conversion of land measuring 21 guntas in survey number 62/6,
Old number.
which was carved out of old survey number 62/4. Stop.
Next year. Next year. A2, page number 18. Not only the land, they are giving other lands is also income.
Huh?
Page 18, page repetitions. Regarding that, I say that
(62 bar) ನಿಮ್ದು ಯಾವುದು?
ನಮ್ದು 62/1B ಅದು ಅದಕ್ಕೆ ಜಡ್ಜ್ಮೆಂಟ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ವಿ ಆ ಕೇಸಲ್ಲಿ ಅವರು ಸೋಲಬಹುದು. Thereafter all these proceedings have been created and these landlords are not the party.
How many times should I repeat? It is not the question about encroachment or title of the property. It is only regarding the Nala. You cannot deny that he also owns a property. His allegation is because you have closed down the Nala, water is now flowing into his property. That is the only allegation we are concerned about. However, before an order of conversion was issued by the deputy commissioner, the deputy commissioner had written to the planning authority, that is Bangalore Development Authority, seeking its opinion regarding the buffer that should be left on the existing Nala, which runs within the property where conversion was sought for. Learned counsel for the petitioner has drawn the attention of this court to Annexure R3 filed along with the statement of objections on behalf of 5, 6, 7, and 10 to 13. Full stop. The said document is a communication dated 30/4/2022 made by the Assistant Director of Town Planning, Bangalore Development Authority, to the Deputy Commissioner, clarifying the position that in terms of the revised master plan -2015 and the zonal regulations, the buffer area has to be left, depending on the type of drain that is in existence in the land in question. Full stop. The contention of the petitioner that it has been opined that the drain running in the property belonging to the contesting respondents is a tertiary drain, and a buffer zone of 15 meters on either side of the drain has to be left. Full stop. Following the said communication, the Deputy Commissioner passed an order of conversion on 12/5/2023, as could be seen at Annexure R3, filed along with the statement of objections on behalf of respondent number 14. So, Learned Counsel points out from the order of conversion that although a communication was made by the Additional Director of Town Planning, Assistant Director of Town Planning, BDA, noticing the fact that there was a nala existing in the property in question and buffer zone has to be left in accordance with the RMP -2015 and zonal regulations, nothing is said about the existence of the nala and buffer area to be left, while passing the order of conversion. Stop. Nevertheless, it is contended on behalf of the petitioner that the contesting respondents herein have closed down the existing nala which was running in their property, and as a consequence of which the storm water is now diverted into the property belonging to the petitioner. Full stop. In this regard, the representations were given by the petitioner. Full stop. Next para. For contra, the contesting respondents have filed statement of objections, and it is not disputed that they have obtained an order of conversion at the hands of the Deputy Commissioner on 12/5/2023. Stop. On going through the conversion order, it is clear that the order of conversion is granted in respect of 21 guntas of land in survey number 62/6 of Benniganahalli village, which admittedly belongs to respondents number
Respondent number 14 and
only respondent number 14, which belongs to respondent number 14 and her relatives and her brothers. Stop.
Purchase. They are claiming to be the now owners. And place it also before the court.
Sale it,
Sale it to the
Opinion, Ray.
house with they are saying something against.
which belongs to the contesting respondents here. Stop. Next para. However, what is required to be considered in this writ petition is whether the allegation made by the petitioner insofar as closing down of the existing nala and as a consequence of which the stormwater is now diverted into the property belonging to the petitioner, comma, if found true, comma, then appropriate directions will have to be issued to the statutory respondents here. Stop. On going through the petition papers, comma, this court finds that an order of conversion has been passed by the Deputy Commissioner on 12/5/2023 in favor of the contesting respondents. Stop. However, it is made clear in the conversion order that the order of conversion is granted permitting the usage of the land for layout - residential purpose. Stop. In terms of the Karnataka Town and Country Planning Act, comma, if the contesting respondents are to form a layout in the land in question, comma, they will have to approach the planning authority seeking sanction of the layout plan. Stop. On the other hand, comma, since the measurement of the property is only 21 guntas, comma, even in terms of the order of conversion, and the said land cannot be formed into a residential layout, comma, there is a possibility of the contesting respondents seeking an approval of a single site layout. Country Planning Act. 17 now. In terms of section 17 of the Karnataka Town and Country Planning Act, 1961. Stop. In any case, comma, the authority considering such an application for sanctioning of the plan at the hands of the contesting respondents herein, comma, the sanctioning authority shall ensure that if a nala is found to be existing in the land in question, comma, then it should be ensured that the nala is not closed down and a buffer zone in terms of the provisions of the RMP-2015 and the zoning regulations shall be maintained. Stop. At any rate, comma, if there is an existing nala on the property in question, comma, the same shall not be permitted to be closed down. Stop. Next para. On the other hand, if it is found that there is no such nala existing on the property in question belonging to the contesting respondents, comma, the question of directing them to maintain the buffer zone may not arise. Stop. It is possible that the nala is existing on the extreme side of the property belonging to the respondents. The photographs hakidiralla. Comma, this is because the respondents themselves have furnished photographs along with the statement of objections showing the existence of a nala. Stop. Under such circumstances, comma, the planning authority will have to take into consideration the provisions of law, including the RMP-2015 and the zoning regulations for reserving the buffer area while sanctioning the plan for construction. Full stop. Next para. This writ petition stands disposed of while directing the first respondent, Joint Director of Town Planning, comma, bracketally North, comma, BBMP, comma, the Tahsildar, comma, Bangalore East Taluk, comma, Kiarpuram, and the planning authority, that is the Bangalore Development Authority, comma, although the authority is not arrayed as a party respondent to these proceedings, comma, that as and when the contesting respondents herein approach the said authority seeking sanction of a plan for putting up construction, comma, they shall ensure that if there is a nala existing on the property in question belonging to the contesting respondents, comma, the same shall not be permitted to be closed down and the buffer zone is maintained in terms of the RMP-2015 and the zoning regulations. So, as noticed herein above, comma, if the nala is existing on the extreme end of the property belonging to the contesting respondents, comma, even then the requirement of leaving the buffer zone in terms of the RMP-2015 and the zoning regulations shall be maintained while approving the plan. Full stop. At any rate, it shall be ensured that no existing nala which is running either in between the property belonging to the contesting respondents or on the extreme end of the property is not closed down or diverted. Full stop. Ordered accordingly.
Issue or you agree?
Huh? Hmm. PDMP.
Section of
Sections will submit as the sections 40 have already right. The instructions were not properly carried out. There is not consideration. Requested the authority to carry out certain. So the instructions I mean.
Here instruction. Here instruction, sir.
Kind of the location of the physical property of the petitioner.
Hmm.
And to measure the actual distance.
ಕೊಟ್ಟಿದಾರಲ್ರಿ, there is a sketch along with the report. Which shows the extent of the kaluve and where the construction is put up.
Clearly mentioning distance between the and well as the it is not clearly. So objections take release. It is a right. Take the objection.
Yes.
You can fully develop and there are no measurement stones available. And the kind of report run, the measurement stones are not available. That was going to be something report. And then it has been created by using the surrounding surrounding land. There were no stones. The past simply like that. So it's very clearly mentioning. There is no survey report, there is no measurement for stuff. We want to the property, measuring the property. So that case, the report has been submitted. The reports are clearly. Our survey that is ready to survey
ಎಲ್ಲಿ ಓದ್ತಿದ್ದೀರಾ? ಪ್ಯಾರಾ 4.
survey that survey ಆಧಾರದ ಮೇಲೆ ನಿರ್ವಹಿಸಿ ಈ ಬಗ್ಗೆ ವಿವರವಾದ ಲಾಸ್ಟ್ ಕೋರ್ಟ್ ಪ್ರಕರಣದಲ್ಲಿ ಸರ್ವೇ ದಾಖಲೆ ಆಧಾರದ ಮೇರೆಗೆ ನಿರ್ವಹಿಸಿದ್ದು ಸ್ಥಳದಲ್ಲಿ ವಾದಿ ಮತ್ತು ಪರಿಗಣಿಸಿ ಅದೇ ಸಮಯದಲ್ಲಿ ವಾದಿ ಮತ್ತು ಪ್ರತಿವಾದಿಗಳು ಗೈರ್ಹಾಜರಾಗಿದ್ದಾರೆ. ಸ್ಥಳದಲ್ಲಿ ಹೇಳಿಕೆ respondents authorities they are not at all present.
ಅಥಾರಿಟೀಸ್ ಅಲ್ಲ.
ಪ್ರತಿವಾದಿಗಳು
ಯಾರು ಪ್ರತಿವಾದಿಗಳು?
respondents.
EBMP official.
Yes, they are not present. They are making this study measure. Very mentioned in the report. And the ಭಾರತದಲ್ಲಿರುವ ಇಲ್ಲ ಅಂತ ಹೇಳ್ಬೋದು. ನಮ್ಮ ಸಬ್ಮಿಷನ್ ಏನಂದ್ರೆ ಇಲ್ಲಿ ಎರಡನೇ ತರ ಇರ್ತಾವ. ಅಲ್ಲಿ ಪುರಾಭಿವೃದ್ಧಿ ಬಡವಣೆಯಾಗಿ ಕ್ಲಿಯರ್ ಸದರಿ 12 ಪರೀಕ್ಷೆ ನಗರಕ್ಕಾಗಿ ಪ್ರಕಾಶ ಸರ್ವೆ ದಾಖಲೆಯಲ್ಲಿ ಕಾಲುವೆ ಸತ್ತಿಗೆ ಇಳಿಸಿದ ಹೇಳಲಾಗಿತ್ತು. ಕಾಲುವೆ ಜಾಗೃತಿ 15 ಟ್ರೈನ್ ನಿರ್ಮಿಸಿತ್ತು. ಕೆಲವೇ ಕಡೆ ಟ್ರೈನ್ ನಿರ್ಮಾಣ ಹಂತದಲ್ಲಿ, ಕೆಲವು ಕಡೆ ವಾದಿಗಳ ಅಂದರೆ ನಿವೇಶನದಲ್ಲಿ ವಾಸದ ಮನೆ ಇತ್ತು. ವಾದಿಗಳ ಸೇರಿರುತ್ತದೆ. ಸದರಿ ಮನೆ ಕೂಡ ಕಾಲುವೆ ಜಾಗದಲ್ಲಿ ಬರುತ್ತದೆ. ಸದರಿ ನಿವೇಶನವನ್ನು ಸರ್ವೆ ನಂಬರ್ 12 ಪಾಲ್ಗೊಂಡ ಜಾಗದಲ್ಲಿ ರೈಟ್ ಪಡೆದಿರುವುದಾಗಿ ದಾಖಲೆ ತೋರಿಸಿದ್ದಾರೆ. ಅನುಭವದಂತೆ ಸದರಿ ಮನೆ ಸಹಿತ ನಿವೇಶನ ಕಾಲುವೆ ನಿವೇಶನ ಸದರಿ ಮನೆ ಸಹಿತ ನಿವೇಶನ ಕಾಲುವೆ ಜಾಗದಲ್ಲಿ ಬರುತ್ತದೆ. But very clearly stated there are no survey scopes available. They are not closed. They should be developed. This is the completely developed land. The entire area has the road segment. The area is completely developed and no survey scopes are available. And promote the statement was recorded first time on 7/4/23. That is a closed document along with the survey state. There are 4 closed documents. Is a 7/4/23 where the signatures are taken of the petitioner as well as the you are Hajarainda. Subsequently, on 12/4/23, no statement hold. On the reason that the survey did not be completed on the first day, that is 7/4/23 survey model. ಸ್ಥಳದಲ್ಲಿ ಹಾಕಿದಾಗಿ ಪ್ರಾರಂಭಿಸುತ್ತಾರೆ. ಭೂ ಸರ್ವೆ ನಿರ್ದೇಶಕರು ಭೂಮಾಪಕರೊಂದಿಗೆ ನ್ಯಾಯಾಲಯದ ವರದಿ ವಾದಿಗಳ ಸೂಚನೆಗಳಂತೆ ಸ್ಥಳದಲ್ಲಿ ಮೂಲ ಗಡಿ ಹಕ್ಕುಗಳನ್ನು ನಿಗದಿಪಡಿಸಬೇಕು. ಸರ್ವೆ ದಾಖಲೆಗಳ ಆಧಾರದ ಮೇಲೆ ಯಾವ ಸೂಚನೆ ವರದಿಯನ್ನು ನಿಖರವಾಗಿ ನಿರ್ವಹಿಸುತ್ತಾರೆ. ಸ್ಥಳದಲ್ಲಿ ನಮ್ಮ ಸಮಕ್ಷ ಅರ್ಚೆ ಮಾಡುವುದನ್ನು ನಾವು ನೋಡಿಕೊಂಡಂತೆ ಸರ್ವೆ ದಾಖಲೆ ಹಾಜರುಪಡಿಸಿದ ಮಾಹಿತಿಯಂತೆ ಸರ್ವೆ ನಂಬರ್ 12 ಉತ್ತರದ ಕಡೆ ಕಾಲುವೆಯನ್ನು ಎಡೆಗುರುಗಳನ್ನು ಸ್ಥಳದಲ್ಲಿ ಗುರುತಿಸಿದ ವಾದಿಗಳ ಅನುಭವದಲ್ಲಿ ವಾಸದ ಕಾಣುತ್ತಾರೆ.
Jagdishwar, see annexure E, page number 49. Page number 49, annexure E. Here a notification has been issued. Official memorandum has been issued on 7/11/2022 by the Assistant Director of Land Records, identifying the officers of the BBMP who are required to for finding out the Nala and the encroachments on Nala. All informations regarding the area and the concerned officer of the BPMP is given at serial number 14, Parappana Agrahara, where this property also falls. There is a name of that officer of the BPMP. Then the surveyor, BBMP officer, then revenue inspector, more information ಕೊಟ್ಟಿದ್ದಾರೆ. ಆಯ್ತಾ? I only want to know if this is the, if you come now to the sketch produced along with the report, where the Nala Kaluve has been shown. ಈ ತರದ ಎಷ್ಟು ಎನ್ಕ್ರೋಚ್ಮೆಂಟ್ ಇದೆ, ಎಲ್ಲರ ಮೇಲೆ ಆಕ್ಷನ್ ತಗೊಂಡಿದಾರಲ್ಲ. The idea is to clear the Kaluve in terms of the directions given by the Honorable Division Bench and the state government. So if this type of a Kaluve is there and a layout has been formed, this will not be the only house that is constructed there. So I only want to know if action is taken by the BBMP, clear all the encroachments. Maybe only the petitioner is before this court. The others have accepted it and they have.
Created the Malad petition under the petition. The batch of business filed. And there is a disposal of the hardship with the direction to make a survey within the party and demolish the building. But we have taken action, we have removed some of the property. But here, the petitioner comes before this court on the ground that before passing an order by the Tahsildar, the JDL, survey is not conducted. Based on that, this court has appointed a new survey. Direction show. Survey has been conducted in the presence of petitioner.
ಅಲ್ಲಿ ಇದರಲ್ಲಿ ಇದೆ ನೋಡಿ, ಅನೆಕ್ಷರ್ ಎಂ ಅಲ್ಲಿ, ಅನೆಕ್ಷರ್ ಎಂ page number 73, 74 ಅಲ್ಲಿ there is another sketch showing not only encroachment by this petitioner, all other encroachments also are shown there, and they have shown the names of the person encroachers.
You have taken action, they are batch and we are removed it, they are removed it. And the is only petition from this court and the ground that no notice should be to making a survey. Therefore, this is directed mentioning make a survey. And the survey has been conducted and we have taken action. The survey report is for the action. There is the entire property built up on Rajkala. It's stated we clearly mentioned at the serial number 3 stage. Let's get it produced on the report. Below marker the complete building is unauthorized, which is on the Rajkala.
Yes, sir.
But
ಏನು ಮಾಡಕ್ಕಾಗಲ್ಲ.
in that regard,
It has to be removed.
that regard, additionally, you know, there is something of that may be very cheap. It goes with that. That can support the for the maintenance. That will make it clear the strategy, situation of the on hand.
Objection.
Very clearly visible. The existing drain adjacent to the that can be fixed.
Huh?
Not with the additional ground.
Huh.
The C. Check that. The next photograph. There, the existing drain is shown. Which is limited to that portion. And subsequently, one more photograph. That's the guidance. Next page. The drain has been widened. Subsequently, also the if then the drain is already the eventually run to water. Especially completed. It's a narrow drain. So that's the guidance. Equally, the drain is widened. Therefore, and distance is also very clearly visible. The second photograph, first page, the photograph is down. The homes in the drain with the distance, and it cannot be in any way That is the area. The nala, the drain is already constructed and no water is flowing and no obstruction to the drain. By sufficiently, the drain is already constructed long back. And it is limited to small measurement. Subsequent portion, subsequent photograph they clearly show the measurement is wider, the width is more. Sufficiently, within photograph clear measurement is also shown. Of that. They clearly identify where ಅದು ಎರಡನೇ ಪೇಜ್ ಅಲ್ಲಿ ನಾವು ಫೋಟೋ ನೋಡಿದ್ರೆ the construction newly constructed page, it shows it is a little bit broader from the earlier page. Now that the measurement is also aeromark like that. Once it was done with all scientific and along with that, the survey map of India is also other than
ಅದೇ ನಿಮ್ಮನೆ ಹತ್ರ ಕಡಿಮೆ ಆಗೋಗಿದೆ.
ಕಡಿಮೆ ಮಾಡಿದ್ದಾರೆ, ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡಿದ್ರು. ಈಗ ಇಲ್ಲಿ ಮನೆ ಹೊಡಿತೀರಾ ಯಾರೋ ಮಾಡಿ ಬಿಟ್ಟಿದ್ದಾರೆ ಅಷ್ಟೇ. ಡೆಮಾಲಿಷಿಂಗ್
ಒಂದು ನಿಮಿಷ ಅದಾಗಿದೆ. ಇದು ಆಗಿರೋದು ಇವಾಗ ನಾವು ನೋಡಿದ್ರೆ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ the construction is not really it is not done for the purpose of the petitioner. That we made which was sufficient for that purpose. Therefore, small bit was there. So it starts from the petitioner. So even earlier that isn't it? I have mentioned the 800 feet of step. Within the agla that can see in the next photograph. And in the third is the fourth photo, and very well clearly visible. The measurement is more, width is more. So agla
ಅದೇ ನಿಮ್ಮ ಮನೆ ಕಡೆಗೆ ಬಂದಾಗ ಚಿಕ್ಕದಾಗಿದೆ.
ಮಾಡಿದ್ದಾರೆ.
ಅಷ್ಟೇ ಅಲ್ಲ ಸರ್.
ಅದೇ ಅಲ್ಲಿಂದ ಮುಂದಕ್ಕೆ ಸಣ್ಣ ಆಗೋಗಿದೆ.
Even it was starting beginning, the measurement is less. And the distance between the drain as well as very much there is a sufficient distance, and the construction is over. I can understand the construction is very low to the house. No, it is height is around 10 feet height. Height also, and the drain water does not flow away. Subsequently, now that the new construction has been the compound side walls, drain compounds, so it is very clearly visible the distance between the house of the petitioner as well as the drain wall. This is not and apart from it,
This appears to be a very big drain. It's very big. ನೀವು ಆ ಫೋಟೋ ಅಲ್ಲಿ ಪೇಜ್ ನಂಬರ್ 8 ಅಲ್ಲಿ ಆ ಡ್ರೋನ್ ಅಲ್ಲಿ ತೆಗೆದಿರೋ ಫೋಟೋ ನೋಡಿದ್ರೆ if you see this down part of it, there is a wall. ಕಾಣ್ತಾ ಇದೆಯಾ?
first photo
ಅಂದ್ರೆ ಇಷ್ಟ ಅಗಲ ಇದೆ ಡ್ರೈನ್ ಆಕ್ಚುಲಿ ಅದು.
ಅದಕ್ಕೆ ನಾನು
see this ಇದೆಯಲ್ಲ ಕೆಳಗಡೆ, that is also a part of the drain. This side ಕೆಳಗಡೆದು ಅಷ್ಟ ಅಗಲ ಇತ್ತು ಡ್ರೈನ್, ಅದನ್ನ ಇಷ್ಟು ಚಿಕ್ಕದ್ ಮಾಡಿದ್ದಾರೆ.
that's sufficient.
What can it cannot help you.
None sufficient. The instructions are very clearly published.
ಏನು ಮಾಡಕ್ಕಾಗಲ್ಲ. It is actually found that the construction has been put up on
What the authority to have taken the like petitioner to show to the court that whether there is actually encroachment or whether it comes in the drain in the area of the SWD. Also, that instructions are given. The aim of the report instructions ಕೊಟ್ಟಿದ್ದು ಅದನ್ನು ಪರಿಗಣಿಸುತ್ತಾರೆ ಸೇರಿಲ್ಲ instructions ಪರಿಗಣಿಸಿದ್ರೆ ಏನು
So you have put up the construction in an unauthorized layout. Is it an authorized layout?
No.
Is it an authorized layout?
Not say private.
Are whether you have purchased the site in an authorized layout or an unauthorized layout? Huh? Are unauthorized layout? Is problem? Sale deed ಇದೆ ಅದ್ರ ಬಗ್ಗೆ ಏನು dispute ಇಲ್ಲ.
The petitioner has been continuously paying the tax. To keep that because the act very clearly says, I have taken up several notes in the.
ಬರ್ಕೊಳ್ಳಿ.
Additional.
Please take down.
My application for additional note pay guidance.
This is the second round of litigation. At the end,
My submission.
full stop. Earlier, the petitioner had filed writ petition number 19124 of 2022. Aggrieved of the action taken at the hands of the respondent BBMP. Which had issued notice calling upon the petitioner to demolish the construction put up by the petitioner on a stormwater drain. Stop. This court, by order dated 28th of September 2022, in a batch of writ petitions bearing WP number 18842 of 2022 and connected matters, directed the Tahsildar concerned and the Assistant Director of Land Records conduct a survey of the subject properties after notifying the petitioners, after notifying the owners, and also the concerned authorities. Full stop. It was further directed that upon conducting the survey, if it is found that the subject properties have been constructed by encroaching the stormwater drain, the respondent BBMP shall take appropriate action after issuing notice to the petitioners. Full stop. It was also directed that till the report is submitted, the respondent BBMP authorities shall not take any coercive action. Stop. Next para. As directed by this court, a survey was conducted and thereafter a notice, the impugned notice dated 23/2/2022 at Annexure M was issued by the Assistant Executive Engineer, Begur Subdivision, BBMP, notifying the petitioner regarding the encroachment on the stormwater drain. So, a survey sketch was also appended to the notice, clearly showing that property number 1, belonging to the petitioner, as shown in the sketch, was fully within the stormwater drain in survey number 12 of Parappana Agrahara village, Beguru Hobli, Bangalore South Taluk. Stop. The sketch also shows that 5 other constructions were found to have been put up on the stormwater drain. Stop. Next para. During the course of these proceedings, an interim order was passed on 1/3/2023 based on the submissions of the learned counsel for petitioner that no notice was issued to the petitioner before carrying out the survey, and therefore the impugned order was stayed. While calling upon the respondents to place necessary documents to show that notice was issued to the petitioner or not. Stop. Thereafter, by another order dated 27/3/2023, this court deemed it necessary to direct the Assistant Director of Land Records carry out one more survey in the presence of the petitioner. So, for that purpose, a date and time was fixed by this court, directing the petitioner to be present at the spot while survey was conducted by the ADLR. Stop. A report was also directed to be furnished to this court on the factual inspection of the property in question. Stop. Accordingly, a fresh report of the Assistant Director of Land Records, along with a report, along with a sketch showing the existence of the construction put up by the petitioner, was furnished to this court on 5/6/2023. Stop. A copy of the same was also served on the learned counsel for petitioner. Stop. Objections have been filed to the report. Stop. Next para. Learned counsel for the petitioner seeks to contend that the survey was not conducted properly. Stop. It was found that the Assistant Director of Land Records was not able to locate the survey shown, and therefore the report should not be accepted. Stop. It was also pointed out from the photographs furnished along with IA number 1 of 2023. It was filed by the petitioner for production of for raising additional grounds. Stop. Photographs taken through a drone camera were also produced along with the application. Stop. Learned Counsel, while pointing out to the photographs, submits that admittedly there is a drain running behind the property in question, and therefore, there is a stormwater drain and the stormwater is flowing without any obstruction at the ends of the petitioner. Stop. It is therefore sought to be contended that taking note of the existence of the nala behind the property in question, a direction may be issued to the respondent authorities not to demolish the construction put up by the petitioner. Full stop. Next para. Having heard the learned counsel for petitioner, the learned counsel for the respondent BBNP, and on perusing the petition papers, this court is of the considered opinion that on the previous occasion, at the asking of the petitioner and several such petitioners, this court had directed the Assistant Director of Land Records and the Tahsildar to conduct a fresh survey in the presence of the parties. And thereafter, if it was found that constructions were put up in the stormwater drain or encroaching a portion of the stormwater drain, then appropriate action was directed to be taken to remove the encroachments on the stormwater drains. Full stop. This court is also aware of the fact that from the past few years, due to the incessant rains, the city of Bengaluru was under floods. Stop. Public interest litigations were filed, which were considered by the Honorable Division Bench, and directions were issued to the state government and all its authorities, including the Commissioner of the BBMP, to take immediate action to clear all stormwater drains from encroachments. Stop. As a consequence of the directions issued by the Honorable Division Bench, the officers of the BBMP and the Tahsildars sprung into action and issued notices to all such owners of the property who had put up constructions encroaching upon the stormwater drains. Stop. This case is also arising out of such an action initiated by the respondent corporation to carry out the directions issued by the Honorable Division Bench. Full stop. Next para. During the course of these proceedings, as noticed herein above, comma, a fresh survey was conducted, comma, since it was contended by the petitioner that the survey was conducted in the absence of the petitioner and no notice was issued to the petitioner. Full stop. It cannot now be denied by the petitioner that a fresh survey was conducted in the presence of the petitioner. Full stop. The report clearly shows that the construction put up by the petitioner is in the stormwater drain. Full stop. Merely because the stormwater drain has been reduced to a small extent, to a very small extent, and provision is made for the stormwater to pass by, comma, behind the property in question, comma, that will not meet the requirements of clearing the stormwater drain. Full stop. This court is also aware of the fact, this court would take judicial notice of the fact that there are mainly 3 types of drains, stormwater drains. And as per the RMP-2015 and the zonal regulations, comma, the width of the drains are required to be maintained without any reduction in their size. Full stop. Of course, comma, buffer zone is also required to be left on both the sides of the drains. Full stop. This is not however, this is not a case where the authorities are complaining of the non-leaving of the buffer zone. Stop. In the present case, the entire construction of the house is on the stormwater drain, comma, as could be seen from the report and the sketch. Full stop. That being the position, comma, no fault can be found in the action of the respondent authorities in issuing notice to the petitioner and calling upon the petitioner to demolish the construction, or the authorities would themselves demolish the construction. Stop. Next para. Having found that there is no merit in the writ petition, comma, this court proceeds to dismiss the writ petition. Full stop. The respondent authorities are permitted to go ahead for clearing the stormwater drain in terms of the impugned notice. Full stop. Ordered accordingly. We continue at 2:30. No adjournments now. We'll see at 2:30.
ಏನಪ್ಪ ಇದು ಅಷ್ಟು ತಾನೇ ಇಟ್ಕೊ. ಬಂದಿತ್ತಲ್ಲ ಒಂದ್ ವಾರ ಕಡಿಬೇಕು ಆಮೇಲೆ ಒಂದು ವಾರ ಹೀಗೆ ಒಂದು ವಾರ ಮಾಡಲ್ಲ. ಅಷ್ಟು senior case ಮಾಡ್ಲಿಕ್ಕೆ very
Ramesh sir.
ಕೊಡಿ. ಹಾ
Yes. And I made one mistake, my lord. The commencement certificate was issued for single plot, not single layout. I have wrongly at the time of application for layout. I verified papers single plot. Because it is not yet released.
The plot
Plot.
under 17,
Layout.
under section 17.
Single plot.
Yes.
Section 21, the other side filing again, and also objections, copies of the way morning. And take steps to authorize the date also. And government has not-
Election matter. Election matter. Yeah, report.
Is it serial number 21, my lord?
Allah, he is only mentioning.
Mentioning.
One matter is there. Please wait, sir. After one matter, your matter. Yes. Yes. Huh? You know? ಯಾವುದು? Who is on the other side? Serial number 29 at the request of Learned Counsel for petitioner. 21. Release this matter on 19th of July. ಸ್ವಲ್ಪ ಇರಿ ಸರ್, ಬಹಳ ಜನ ಇದ್ದಾರೆ. ಇನ್ನು 2 ಮ್ಯಾಟ್ರು. ಕಮ್ ಅಪ್, ಪ್ಲೀಸ್ ವೇಟ್. ಬಟ್ ಅದರ್ ಸೈಡ್ ಇಲ್ಲ ಅಂದ್ರೆ ನಾನು ಅರ್ಜೆಂಟ್ ಮಾಡಲ್ಲ ಸರ್. ಎಸ್ ಅಲ್ಲ, ಹೇಳೋದಲ್ಲ. ದೇ ಹ್ಯಾವ್ ಟು ಬಿ ಹಿಯರ್. ಎಸ್. ಹಾ 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 ನೋಡೋಣ, ಲೆಟ್ ಅಸ್ ಸಿ. ಎಸ್ 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 ನೋಡ್ರಿ, ಇವ್ರಿಗೆ ಹೇಳು, ಹೂ ಇಸ್ ಕಮಿಂಗ್. ಏಜ್ ಇಸ್ ಕಮಿಂಗ್. ಪ್ಲೀಸ್ ಆಸ್ಕ್ ಹರ್ ಟು ಕಮ್. ಎಸ್.
Responding. Concerning that, we are supposed to be concerned area to proceed for survey matter.
Huh?
It's a date matter.
Oh, yes. Yes.
The approach to be concerned ADLR.
Huh?
ADLR. Suppose that will make a survey.
Huh?
Distance of ADLR. Now, they are considering the approach to be concerned ADLR. ADLR date, it's a date matter in so far as survey is conducted.
No. A date was given.
Yes, madam. Yes.
A date was given for the second time to carry out the inspection on 15/4/2023 and to submit a report.
Not carried out because perhaps there was an election. Because there was an election proceedings and they were not cooperative at the time. All the threats are being electoral process. Now the approach should be concerned the area of Manatee.
No. This attitude is not going to be appreciated. No.
They will carry out the.
No.
I apologize.
No. No, sir. We'll inform the commissioner to take action against this officer who doesn't care to comply with the directions given by this court. Let him not be there. If he has the scant regard for the orders of this court, then we will show him what High Court is. ಏನ್ರಿ ಎರಡನೇ ಸರಿ ನಿಮಗೆ ಟೈಮ್ ಫಿಕ್ಸ್ ಮಾಡಿದ್ದು. ಮುಂಚೆ ಒಂದ್ಸರಿ the first time it was 15/4. Then again 20th of May ಎರಡನೇ ಸರಿ ಡೇಟ್ ಫಿಕ್ಸ್ ಮಾಡಿದ್ರು. ಏನ no question of sorry. No. ಬರ್ಕೊಳ್ಳಿ. This court had directed the respondent assistant executive engineer ಯಾವ ಸಬ್ ಡಿವಿಷನ್ ನಿಮ್ದು? ಮಾದೇವಪುರ ಸಬ್ ಡಿವಿಷನ್, BBMP to carry out an inspection on 15/4/2023, mark the boundaries and or nala as claimed by the respondent in the presence of the petitioner. Full stop. The said order was passed on 5/4/2023. Full stop. Thereafter, when the matter came up on 20th of April 2023, the learned counsel for the respondent BBMP submitted that due to the intervening elections, the engineer could not conduct the inspection on 15/4. Stop. Taking note of the said submission, this court directed the inspection to be carried out on 20th of May 2023 and to file a report. Stop. The matter came up on 12th of June 2023 and learned counsel for the respondent BBMP sought for some more time to file the report. Full stop. Once again, on 26/6/2023, the matter was adjourned for compliance of the directions issued by this court. Full stop. On the previous occasion, that is 3rd of July 2023, again the learned counsel for the respondent BBMP sought for 10 days time to submit the report. Full stop. Next para. The chronology of events clearly show that the respondent assistant executive engineer Madhevapura subdivision BBMP has scant respect for the orders of this court. Full stop. The commissioner, chief commissioner, BBMP is hereby directed to take action against the assistant executive engineer and report to this court the action taken against the engineer. Full stop. Next para. Release this matter on 12th of July.
So that we carry out the direction. I want the corporate engineer.
No.
If you have a part and this comes for the consultation.
A copy of this order shall be served on the learned counsel for the respondent BBM. Yes.
IAPA for the respondent number 14, my lord. I am the contesting respondent in the case. You will also kindly see. May I make one submission, my lord?
recounting.
Recounting, yes, my lord.
Ah.
May I make one submission, my lord?
Yes,
On this honorable court on 12/4, order for recounting and on 25/23. Now the report is submitted by the AG saying that
both have secured the same.
equal
number
number
of
of votes. But my client says, and we have filed an affidavit also today, saying that on the date of recounting, they have declared on the spot saying that my client, that is respondent number 14, got one more vote than the petitioner, and that has been it is recorded. Now they file a report saying that it's equal. Actually, one more vote, they declared at that time on 20th May on the spot saying that respondent number 14 got one extra vote than the petitioner. Now they file a report like this. That CD recording is there, is what my client says. Let them produce the CD. Your lordship may observe or go through that and find out what exactly has happened. I do not know.
We can't go by the statement made there. We are required to find out the actual number of votes that are cast.
Let it be
What is
recounted.
the use of going by statements made there?
No, let it be recounted, because I have the information saying that one vote which was rejected earlier, which was held to be valid during that discussion, and it has to be added to my client. And I think recounting has to be ordered if the report is wrong.
No.
I am challenging the report.
How many times recounting?
Only once, my lord. Only once recounting has been done.
No. Who is this returning officer?
One more submission I want to make is this, my lord.
Huh? His name is there? Would you please give a copy?
And one more submission I want to make by this, my lord, with your lordship's kind leave.
Yes.
I am filing an application saying that the petitioner be restrained from acting as till your lordship decides who is elected. Now say that equal. Earlier report was different, and now they say equal. And now I am challenging that report. If till your lordship decides, let him not function as a panchayat member, because 2.5 years they have already, based on the earlier wrong election declared, which is now held by the civil court as invalid. The civil court has held it invalid, and now he is functioning. Let it be restrained from functioning till your lordship decides the matter, is what I am seeking by application. Even 2.5 years wrong order. Now the civil court held that it is wrong, invalid declaration. She is not elected. Now she is functioning. Of course, that is now challenged before your lordship, but the position is this. And she has enjoyed 2.5 years already on the basis of that declaration. Now let them prevent, or in fact, my client, the remaining portion, let them have at least by way of equity, at least something.
See, the returning officer was not permitted to announce the results. It has been placed before this court. Where is the question of the petitioner functioning in terms of the?
No, there is a stay order. There is a stay order of the election petition order.
Correct. It is in favor of the petitioner.
Then she will be functioning because there is a stay.
That is on the ground of hearing the parties on the question of interim prayer.
that was passed.
It
ex
is not
parte, my
because
lord.
of this subsequent
that-
recounting, sir.
No, not that I'm
That,
saying.
that cannot be changed now.
No, there is an ex parte order, my lord. Ex parte
Wait,
order.
please wait.
Ex
Please
parte
wait.
of stay. Ex parte order of stay.
Yes, yes.
The civil court has declared that election declared is invalid. That is now stayed by your lordship by ex parte order. That is
Yes,
how
Barkali.
she is functioning.
Bar-
Based on that ex
The-
parte order, she is functioning.
ಇದನ್ನ ನೀವು ಲಾಸ್ಟ್ ಟೈಮ್ ಕೊಟ್ಟಿದ್ರಲ್ವಾ? You have taken it on record? No. Was it placed before the court?
Yes.
ಇಲ್ಲ. We had directed that it will be filed in the office.
And copy to be given to us.
Office ಅಲ್ಲಿ file ಮಾಡಿಲ್ವಾ? ಏನಮ್ಮ ನೀವು, that is what we are directed. Learned AGA has filed a memo dated 5/7/2023 along with a copy of the declaration made in form number 36 by the returning officer. Stop. Learned counsel for the contesting respondent number
14, my lord. 14.
14.
14. 14.
14
14.
submits that in the declaration form, it is shown that the petitioner as well as the as well as respondent number 14 have both secured 584 votes each. Stop. Learned counsel for respondent number 14 submits that on the day when the recounting was carried out, it was announced that respondent number 14 has got one vote more than the petitioner. Learned counsel submits that there are video recordings of the declaration made by the returning officer. Stop. However, a different declaration is made and is placed before this court. Stop. Next para. Release this matter on 12th of July 2023. Stop. The returning officer who conducted the recounting shall be present before this court on the next date of hearing. Full stop. The ballot papers shall also be brought along with the returning officer. Let us please have a copy on the learned counsel for petition. Our bidre, our then there is nothing now. New steps ತಗೊಂಡಿಲ್ವಾ? ತಗೊಳ್ಳಿ. Next para. A week's time is granted at the request of the learned counsel for petitioner to take steps to the unserved respondents. Yes.
And my IA may posted for order on that day, my lord. The IA saying that based on the stay, ex parte stay order is continuing, that I am asking to be reviewed, that IA. So that IA today I am giving, my lord. That
ಅದಾಗಲ್ಲ sir. The matter is to be decided finally.
very well, my lord. 12th, my lord. 12th, my lord.
12th.
I'll be there. Apply, my lord.
Huh? At the request of the learned counsel for petitioner, release this matter on 12th of July. Huh? Same ಅದೇ ತರ. Huh? Hmm. They have conducted it. Hey, what is your?
Yes, my lord, it has been conducted.
Huh?
It has been handed over to office member. Friday, my lord, I will be filing copy of the inspection report also. Kindly pardon them for.
Why Friday?
It
It is ready ತಾನೆ?
is ready, but
Please do it tomorrow itself.
please.
Learned Counsel for the respondent BBMP submits that the report is ready and the concerned Assistant Executive Engineer is present before this court. Response number? Response number 2, 3 and 4 are present before this court. Full stop. Learned Counsel submits that the report will be submitted in the office by tomorrow. Full stop. A copy of the same shall be served on the Learned Counsel for petitioner as well as the contesting respondent. Yes. Release this matter on 12th of July. ಕೊಟ್ಟಿಲ್ವಾ ಕಾಪಿ ಕೊಟ್ಟಿಲ್ವಾ matter is called out. There is no representation for the petitioner. Learned Counsel for respondent number 4 submits that he has not received copies of the writ petition. Stop. Learned Counsel for the petitioners is directed to serve 2 sets of copies of the writ petition along with annexures on Learned Counsel for respondent number 4. Stop. Release this matter on 12th of July. Interim order granted earlier and second IDAS serial number 21.
45. You want to repeat? Or we.
On 28/6/2023, the following order was passed. Extract monitoring. Next paragraph. Matter is called out. There is no representation for the petitioners. Full stop. Consequently, the writ petition stands dismissed. Election matter. We will call it a career matter.
Outdoor matter.
Yeah, please wait, sir. But in today's newspaper, they have said the calendar of events will be announced tomorrow. No, they have been directed to announce the calendar of events tomorrow. That is what has been published in the newspaper. Huh? This is a second half. Allah sorry, but now you will definitely take a stand that calendar of events are announced and nothing can be done now. Yen model. So if ಇವಾಗ ಫಾರ್ ಎಕ್ಸಾಂಪಲ್ ನೆನ್ನೆ ಮ್ಯಾಟರ್ ಅಲ್ಲಿ they were saying that another constituency it can be swapped and ಅದೇ ಕಾನ್ಸ್ಟಿಟ್ಯೂನ್ಸಿ ಅವರು ಇಲ್ಲಿ ಇನ್ನೊಬ್ರು ಅವರು ಪಿಟಿಷನ್ ಹಾಕಿದ್ರೆ then both of them are asking for the same prayer, then it can be done. ಏನ್ ಮಾಡೋದು ಮತ್ತೆ?
Automatically.
ಟರ್ಮ್ ಅಲ್ಲ ಟರ್ಮ್ ಮೈ ಟರ್ಮ್ ವಿಲ್ ಗೋ ಅಂದ್ರೆ ಹೌದು. ಏನ್ ಇಟ್ ಗೋ ಅಂದ್ರೆ ಏನ್ ಅರ್ಥ?
ನಾವು ನೆಕ್ಸ್ಟ್ ಯಾರು ಅವ್ರಿಗೆ for example, serial allotment agency. Both the matters, both the cases are panchayat. Both president and vice president of both the reserve for female category. Not possible under their own order.
It is not possible antalla. See, as far as possible.
As far as possible.
Yes.
Here, you can understand if there are no male candidates, you can understand the other category.
ಹೌದು. ಇಲ್ಲೂವರೆಗೂ ಯಾರಿದ್ರು? ಇಲ್ಲಿವರೆಗೂ ಇವತ್ತಿನವರೆಗೂ ಯಾರಿದ್ರು? ಮೇಲ್ 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 ಕ್ಯಾಂಡಿಡೇಟ್. ಮತ್ತೆ ಆಯ್ತು, ಇಲ್ಲಿವರೆಗೂ ಟಿಲ್ ಟುಡೇ ಇವಾಗ ಅಟ್ ಪ್ರೆಸೆಂಟ್
ಅದು ಇನ್ನು ನೆಕ್ಸ್ಟ್ ಅದಕ್ಕೆ ಕಂಟಿನ್ಯೂ ಆಗಬೇಕು, ಬೇರೆ ಯಾರು ಆಗಲ್ಲ. Otherwise, election will get to yellow, everyone wants power. A power should be rotated in accordance with law, in accordance with the own guideline. As far as possible, provide money.
Oh. ಹಂಗಾದ್ರೆ ಸರ್. Then I will record a submission that even if calendar of events are announced, it will not prevent this court from passing orders if it is found that the directions are necessary.
The serial.
Perfect.
Same the victim by the father.
ಅದರಲ್ಲಿ ಸೀರಿಯಲ್ ನಂಬರ್ 1 ನಿಮ್ದು ಯಾವುದು? 6 ಮತ್ತೆ 57. ನೋಟಿಸ್ ಇಶ್ಯೂ ಮಾಡಬೇಕು. ನೋಟಿಸ್ ಇಶ್ಯೂ ಮಾಡಬೇಕು. ನೋಟಿಸ್ ಯಾವ್ದ್ರಲ್ಲಿ ಇಶ್ಯೂ ಮಾಡ್ಬೇಕು ಅದ್ ಹೇಳ್ರಿ. ಸೀರಿಯಲ್ ನಂಬರ್ 1 and 6 ಅಲ್ಲಿ HCDP ಯಾರಿಗೆ, ಮತ್ತೆ ಇವರು ವೈಶಾಲಿ ಹೆಗ್ಡೆ ಅವ್ರು ಯಾವ್ದಕ್ಕೆ, ಆಮೇಲೆ ಇನ್ನೊಂದು ಡಿಸ್ಪೆನ್ಸ್ ವಿತ್ ಫಾರ್ ದಿ ಟೈಮ್ ಬಿಂಗ್ ಅಂತ ಮಾಡಿ next para. The learned additional advocate general is present before this court. The learned counsels for the petitioners submit that today's newspapers carry an information that the calendar of events are directed to be announced tomorrow, that is 6th of July 2023. Full stop. If the calendar of events are announced, the writ petitions will become infructuous. Full stop. Next para. Learned AGA submits, additional advocate general submits that in all these cases, there are some material information that are available to show that the selection of the category and reservation have been done through a computerized process and no manual intervention was permitted. Full stop. In some of the cases, the reservation had to be done by picking a draw, which is also in terms of the rules and guidelines. Full stop. Nevertheless, it is submitted that since the learned additional advocate general is required to make submissions in all these matters after getting the factual information and instructions, the matters may be taken up on 10th of July. Full stop. Next para. Acceding to the request made by the learned additional advocate general, list this matter on 10th of July 2023. Full stop. However, it is made clear that even if calendar of events are announced, if this court finds that directions may be issued to make some changes which would not intervene in the course of the elections, the same will be done irrespective of the fact that calendar of events are announced. Full stop. Yes. Elladrullu ade same order. Huh?
Next matter, sir.
The serial number ಹೇಳ್ಬಿಟ್ಟು ಯಾವುದು?
52, 57.
Election petition 56 26 at 26 ಇಲ್ಲ ಇದು or 26 ಹೇಳಿ. Yes.
Not complying immediately economic method, effective election, later on method, the number 14. The order.
Yes.
The order question, the declaration dated 30/12/2020 that the respondent number 1 petition is the returning candidate reserved category and 20% of Magenta Gram Panchayat. Declaration given by the declaration of here marked as a marked as a documented. It will be marked as a in this case, the declaration given by the declaration of results given by the election marked as a document. It will not be marked as a declaration of without marking the document without
That is not enough, sir. That is not enough.
Second problem is the technical problem is that the document and it will be filed as per method as prescribed in the law.
Hey, merits ಮೇಲೆ ಏನಾರು ಹೇಳ್ರಿ. Not all this. That is not going to cut any ice here.
On merit method. This is the law. Because minority certification document method filed by respondent number 1 petitioner there. They wrongly stated the number of the bar number, that is 120. Yeah. In spite of stating 127. these corrections may be overlooked. The airport observed that these objections may be overlooked as per the provision of section rule 14 of the conduct of election rule. But my lord, the evidence of the returning officer, my lord, page number 96 and 97. File number 19. Verification in the ನಾಮಪತ್ರ ಸಲ್ಲಿಸಿದ ನಂತರ ಯಾವುದಾದ್ರೂ ಕಾರಣದಲ್ಲಿ ತಪ್ಪಿದರೆ ಸರಿ ಮಾಡುವಂತೆ ಮಾಡಿಕೊಂಡು ಅರ್ಜಿದಾರರು ಮುಂದುವರಿದು ನಾಮಪತ್ರವನ್ನು ಪರಿಶೀಲಿಸಿ ಸರಿ ಮಾಡಿಕೊಡುವಂತೆ ಹೇಳಿದ್ದು ಅರ್ಜಿದಾರರು ಸರಿ ಮಾಡಿಕೊಳ್ಳಲು. Thereafter nomination was rejected. Yes, challenge, my lord. Yes, given a provision to correct the mistakes done in the nomination paper. He has not used to correct the mistakes committed by him in the nomination. Later on, after rejecting the nomination, yes, filed the election petition challenging the intent of election proceeding. Election proceeding is null.
On what ground?
On the ground, my lord, that the objection has to be overlooked as per section 43 of the conduct of election.
You were the return candidate. What was the ground on which your election was challenged?
Improper rejection of the nomination paper of the respondent number.
Andre, your nomination paper should have been rejected.
Respondent number 1, petitioner there. The nomination paper
Was rejected.
This nomination paper was rejected. He has challenged the election, saying that it is improperly rejected. My lord, he has given a chance to rectify the mistake. He has not rectified it. Thereafter, it was the evidence of the returning officer is very clear in page number 96 and 97, para number 19. ತಹಶೀಲ್ದಾರ್ ಮುಂದೆ ನಾಮಪತ್ರವನ್ನು ಪರಿಶೀಲಿಸಿ ತಪ್ಪು ಸರಿ ಮಾಡುವಂತೆ ಹೇಳಿದ್ದು ಅರ್ಜಿದಾರರನ್ನು ಸರಿ ಮಾಡಿಕೊಳ್ಳಲಿಲ್ಲ. Thereafter, my lord, in the scrutiny stage, we have not used the correct mistake, rectified mistake, my lord. Then, my lord, his nomination was rejected. Then election was conducted, the declaration was announced, and the certificate issued under section 95, my lord. And he is only using my lord, even my no prayer aspect, my declaration aspect. The election, the prayer should be specific. There should be prayer of the result by the state election commission has to be set aside. There is no such prayer. Election proceeding is at page number 20. Page number 47. It says declare the nomination paper by the in the election valid. Consequently, declare that the election held on 27/12/2018 is valid. The declaration on 30th 2021. Commission has declared me as the returning candidate. That I include a certificate. The specific, without specific prayer. In the election petition itself is fact.
Purple. This election is conducted by whom?
Conducted by the state election.
Our party name madilla.
Returning candidate. Trial vote may not. Returning candidate.
Returning officer. Returning officer.
The election.
No. See, the returning officer cannot come directly before this court and give information. There has to be an authority who is competent to have appointed this returning officer, who should also be arrayed as a party respondent. Allah aitre, here when you filed writ petition, Yenapa, HCP, returning officer of the Gram Panchayat. You take notice, is it? Huh? The returning officer is appointed by the election commissions. Huh? Returning officer. Howda? Issue emergent notice to response number 1 to 11. Returnable by 19th of July 2023. Stop. Learned HCGP takes notice for respond number 12. Stop. Learned counsel for the petitioner is directed to serve 2 sets of copies of the writ petition along with annexures on the learned HCGP. Full stop. Next para. Learned counsel for the petitioner submits that respondent number 1 herein filed an election petition in EP number 2 of 2021 before the principal senior civil judge and JMFC at Beltangadi, Dakshin Kannada, challenging the election of the petitioner to the post of it is only a membership of the Gram Panchayat. So ಅದಾದ್ಮೇಲೆ ಅಧ್ಯಕ್ಷ and ಉಪಾಧ್ಯಕ್ಷ were elected.
Members of the petition submit that respondent to one way in file a election petition before so and so challenging the election of the petitioner.
Election of the petitioner and respondents number 2 to 11 as members of the so ನೀವೊಬ್ರೆ elect ಆಗಿತ್ತು from that ward. Election of the petitioner on the ground that the nomination paper filed by the first respondent was wrongly rejected by the returning officer. Stop. Learned counsel submits that the election to the Gram Panchayat was held on 27/12/2020, and thereafter the election to the post of the Adhyaksha and Upadhyaksha of the Gram Panchayat were also held, and the Gram Panchayat has been functioning accordingly. Stop. The election tribunal could not have set aside the election only on the ground of the wrongful rejection of the nomination papers of respondent number 1 herein. Stop. Learned counsel submits that at this juncture if the elections which were held on 27/12/2020 is declared void at the instance of the first respondent, the functioning of the Gram Panchayat itself will be in peril. Full stop. Next para. Consequently, there shall be an ad interim order of stay of the impugned judgment dated 1st of April 2023 in election petition number 2 of 2021 passed by the principal senior civil judge and JMFC, Beltangadi, Dakshin Kannada, till the next date of hearing. Office objections ಏನ್ರಿ? Office objections shall be complied within a period of 2 weeks from today.
Yes.
Lord. The parties herein, along with the learned councils, have filed a joint memo dated 5/7/2023 reporting settlement. Stop. The petitioner, in terms of the joint memo, the petitioner has agreed to receive a sum of rupees 85 lakhs from the respondent, and the respondent shall pay the said sum within a period of 12 months from the date of this order. Stop. Next para. Learned councils would therefore submit that the prayer made in this civil miscellaneous petition for appointment of an arbitrator has become infructuous. Stop. Next para. Consequently, the civil miscellaneous petition stands disposed of in view of the settlement arrived at by the parties and in terms of the joint memo filed by the parties.
I have waited 10 days from the date of the law. I have waited 10 days for that. That's quite proud and motivated. And my title confirmed that it's one of the leading certificate. Therefore, when I got, I also filed an application for Sorry. Just report, take out the order.
Order on IA number 1 of 2023. 4, 1 of 2023. 1 and 3. 3 condonation. ಅದಕ್ಕೆ 1 ಅದನ್ನೆಲ್ಲ ಮಧ್ಯದಲ್ಲಿ ಸೇರಿಸ್ಬಿಟ್ರಲ್ರಿ ನೀವು ಆ ಅಪ್ಲಿಕೇಶನ್ ಮಧ್ಯದಲ್ಲಿ ಸೇರಿಸಿದ್ರ ತಗೊಂಡೋಗಿ 1 and 3 of 2023. These applications are filed to recall the order dated 12th of April 2023, whereby the civil miscellaneous petition was dismissed for non-taking of steps for service of notice on the respondent. Full stop. Next para. Learned counsel for the petitioner submits that the petitioner had taken steps twice for service of notice on the respondent, and both the times the notice returned with postal shara returned unserved. Full stop. It is contended that though the respondent, though the proprietor of the respondent firm is residing, ಅಲ್ಲ ರೀ ಇಲ್ಲಿ 2 ಅಡ್ರೆಸ್ ಇದೆಯಲ್ಲ, 2ಕ್ಕೂ ತಗೊಂಡಿದ್ರ ನೀವು? ಈ ರೆಸಿಡೆನ್ಷಿಯಲ್ ಅಡ್ರೆಸ್ ಒಂದು ಕೊಟ್ಟಿದ್ದೀರಾ, ಆಫೀಸ್ ಅಡ್ರೆಸ್ ಒಂದು ಕೊಟ್ಟಿದ್ದೀರಾ. Have you taken steps to both the addresses? You have taken steps to both the addresses? See, you have given 2 addresses. So you had the benefit of taking notice to both the addresses. ಮತ್ತೆ ಮಾಡೋದು ನೀವು. ಅದ ನೋಡ್ರಿ, ಅದು ಯಾವ ಅಡ್ರೆಸ್ ತಗೊಂಡಿದ್ದಾರೆ? ಅಡ್ರೆಸ್ ಯಾವ್ದ್ರಿ ಅದು? ಕೊಡಿ. You've taken steps to both the addresses.
It is contended that though the proprietor of the respondent firm is residing
in the address shown in the cost title and has been functioning from the address shown in the cost title, and those steps were taken twice to both the addresses, comma, the respondent is evading service of notice. Full stop. Learned counsel would therefore submit that another application in IA number 2 of 2023 has been filed seeking leave of this court to take out substituted service by paper publication to the respondent. Full stop. Next para. Accepting the submission made by the learned counsel for the petitioner, comma, order dated 12th of April 2023 is recalled while imposing costs of rupees 2,000 on the petitioner payable to what of sir? Karnataka Advocates Welfare Fund. Stop. The cost shall be paid within a period of 1 week from today, and an acknowledgement for the same shall be. ನೀವು ಕಟ್ರಿ ಆಮೇಲೆ ತಗೊಳ್ರಿ ನಿಮ್ ಕ್ಲೈಂಟ್ ಹತ್ರ. And acknowledgement for payment of cost shall be filed in the office. Full stop. Next para. Consequently, while condoning delay, comma, the applications are allowed and the writ petition, civil miscellaneous petition is restored to its original file. Full stop. Next para. Insofar as IA number 2 of 2023 is concerned, comma, the petitioner can be permitted to take out substituted service only after steps are taken thrice to the respondent. Full stop. Therefore, the petitioner is permitted to take out fresh steps for service of notice on both the addresses given in the cost title, comma, within a period of 1 week from today. Full stop. Yes. Huh? Since learned counsel Sri DC Jagdi has entered appearance for the petitioner, comma, the learned name of learned counsel Sri BN Sivanna may be removed from the cause list. Full stop. The petitioner has paid cost of rupees 25,000 as was directed on 23/2/2023. So yes. ಇವಾಗ ಎಲ್ಲಿಷ್ಟೇ 2016 ಮ್ಯಾಟರ್. ಏನ್ ವಾಟ್ ಇಸ್ ದಿ ಮ್ಯಾಟರ್ ಅಬೌಟ್? ಟರ್ಮಿನೇಷನ್, ಕನ್ಫರ್ಮೇಶನ್. Release this matter on 12th of July.
This is not
Notice has been issued? Has been issued. Yeah. Only one person. Yes. Order on IA number 1 to 3 of 2022. These applications are filed to bring on record the legal representative of deceased respondent number 2, while seeking condonation of delay of 140 days in filing the application and to set aside abatement. Stop. Next para. Learned counsel for the petitioner submits that the petitioner was not aware of the death of the second respondent. Stop. It appears that respondent number 2 passed away on 22/4/2021, and the petitioner came to know about the same Mr. Lourdes Mariappa is appearing for respondent number 2. He has not entered appearance for respondent 2A. Note check ಮಾಡ್ರಿ. Respondent number 2A ಗೆ ವಕಾಲತ್ ಫೈಲ್ ಮಾಡಿದಾರ ನೋಡಿ, ಲೂರ್ದು ಮರಿಯಪ್ಪ. Came to know about the same only a few days before the applications were filed. Stop. ಮಾಡಿಲ್ಲ. ಎಲ್ಲ ಮಿಸ್ಟೇಕ್ ಇರ್ಬೇಕು. Learned counsel would further submit that although a learned counsel was appearing for respondent number 2, no information was given to the petitioner or to this court regarding the death of the second respondent. Stop. Next para. Accepting the submission of the learned counsel for petitioner, delay is condoned, abatement is set aside, and the applications are allowed, permitting the petitioner to bring the legal representative of deceased respondent number 2 on record. Full stop. Learned counsel for the petitioner shall carry out the amendment in the cost title and furnish amended cost title within a period of 1 week from today. Yes. You are early hearing. Here, what public road? If it is a private dispute between the parties, no action can be taken by the respondents. You will have to approach the civil court. If there is encroachment on a public road, huh? Then this is not a private interest matter. There is no private interest of yours involved here. Mr. Somyaji,
Yes, sir. ಅದು second
Ah.
appeal pending ಇದೆ. RSA number 1676 of 2019 is pending, my lord.
who has filed?
ಇಲ್ಲಿ contesting response ಇದ್ದಾರೆ.
Have you stated in your memorandum of writ petition regarding civil dispute? That is civil dispute in OS number 227 of 2012 filed by the petitioner's brother has now reached. Yenagide? What was the suit for? Allah, petitioner's brother. Allah, filed by petitioner's brother. ನೀವು ಹಂಗ್ ಬರ್ದಿಲ್ಲ ಇಲ್ಲಿ. ಫೈಲ್ಡ್ ಬೈ ಪೆಟಿಷನರ್ ಬ್ರದರ್ ಅಂತ ಹಾಕಿದ್ದೀರಾ. See paragraph number 4. Please get full information. Then what is this suit about? What is that RSA who filed?
Page number 18, page number 18 can you look into?
If it is a dispute between two private parties, the Gram Panchayat will not interfere.
Page number 18 can you look into? RSA ಅವರೇ produce ಮಾಡಿ. RSA ಅವರೇ produce ಮಾಡಿ. 18 page number 18. Filed by the 8th respondent, Nagaraju and another.
Allah, there's only an order ಅಷ್ಟೇ.
ಅದು ಸ್ಟೇ ಇದೆ, ಅದು ಪೆಂಡಿಂಗ್ ಇದೆ.
That dispute pertains to the dispute between the petitioner's brother and the respondent 8 and 9, and that pertains to only 1345. Under 1345 was granted to petitioner's brother. That is the main matter. This pertains to the right of way.
Alri, please read that order in page number 20. Allah, order dated 24/10/2019 in RSA. Page number 20, ink page number 20. Sikta, order dated 24/10. The second paragraph. ಯಾವ್ರಿ ಓದ್ತಾ ಇದೀರಾ ನೀವು? ಸೆಕೆಂಡ್ ಪ್ಯಾರಾ ಇಸ್ ದಿಸ್ ಅಪೀಲ್.
do the ticket tracking for working in that. However, it has been found by the respondent number 1 in RA number 12 or 18 on the 21st day. The right report judgment said that the suit is dismissed. Appeal was in favor of the petitioner. The learned counsel for the evidence of that there is no dispute that the evidence of the word of max. However, the dispute is about possession and usage of land. In fact, the evidence on that point to the
Therefore, the dispute itself is regarding the acre of land. Then Somyaji avare, you please look into the papers and make your submissions. If the matter is a dispute between the private individuals inter se, the property of the gram panchayat is not involved, then you can make a submission.
ಅದು ಅಲ್ಲಿ ರೋಡ್ ಅಂತ ಹೇಳಿ ಈ ಆರ್ಡರ್ ಇದೆ, ರೋಡ್ ಅಂತ ಹೇಳಿದೆ. I will make a submission.
At the request of learned counsel, Shri B.J. Somyaji, released this matter on 12th of July. Yes.
Maybe post in B group.
Huh?
B group ಹಾಕಿ ಹೆಂಗೆ ಮಾಡ್ಬೇಕು?
B group ಬೇಡ, we can dispose it of next week.
ಸರಿ.
If you make a submission that no part of the gram panchayat is involved, it's a private dispute between two parties that can be resolved only by the civil court.
ಹೌದು, ಈಗ ಇದ್ರಲ್ಲಿ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದಲ್ಲ ಆರ್ಡರ್ ಇದೆ ಸ್ವಾಮಿ, ಆ ರೋಡ್ ಅಂತ ಇದೆ, ರೋಡ್ ಬಗ್ಗೆ ಇದೆ.
ಅವ್ರು ಹೇಳ್ತಾ ಇರೋದು other than that, I am asking for the clearance of the road which is formed in the gram tana property ಅಂತ ಅವ್ರು ಹೇಳ್ತಾ ಇರೋದು. Please look into the papers and make submissions.
ಅಲ್ಲ, ಈ ಆರ್ಡರ್ ಇದೆ, ಅದಕ್ಕೆ ರೋಡ್ ಅಂತ ಹೇಳ್ಕೊಂಡು ರೋಡ್ ಬಗ್ಗೆನೇ ಡಿಸ್ಪ್ಯೂಟ್ ಇರೋದು. ಈ ಆರ್ಡರ್ ಓಕೆ, ಪೇಜ್ ನಂಬರ್ 20
please come next week. Yes.
ಓಕೆ.
Yes. Who has filed IA for impleading? What is the matter about? Who has filed a suit for injunction?
Now the proposed respondent filed suit for injunction. Not going to see paragraph number.
Anyway, we'll see now. Today the matters come up for hearing on this IA. If you say, all right, perfect.
I produced the copy of the claim, wherein they admit the ownership of the petitioner, and they also admit it's a part of the same survey number which was purchased jointly by him and the proposed respondent. If that is the case, just 1 minute, your lordship will kindly see paragraph 17 and page 17. Land is purchased jointly by the petitioners and the respondent. Paragraph number 17, at page number 17. Next page 17. This is the copy of the plate filed by the respondent.
Page number 71.
Copy of the plate. It starts from page 68. 7-1.
Page initial mistake ಇದೆ. Annexure ಯಾವುದು?
Annexure H.
Nandu, it commences from page number 75.
Paragraph 17, you will not.
Who has filed this? Who has filed this suit?
Not the proposed respondent.
Ah,
He says, my lord, that it is submitted the property of the plaintiff, survey number 4 acres, and the property of the defendant is more than 1.5 kilometers.
and
Now,
hence,
he also admits,
having no other alternative, the plaintiff is approaching this honorable court.
he says, my lord, that my land is of 1.5 kilometers away from his land.
Ah.
But still I am interfering, my lord, in the submit substance of that. But this property, my lord, was purchased jointly, my lord, by them, consisting of 8 acres. Afterwards, my lord, it is divided, my lord, 4 acres each. How can it be 1.5 kilometers away, my lord? This is only a Windows.
Alala, who purchased jointly?
That is later the petitioner's vendor and the proposed respondent. Jointly purchased. Thereafter, my lord, there is a division of the property. 4 acres has gone to them, not 4 acres to my vendor. Now he says, Lord, my property is 1.5 kilometers away. Just to see that, Lord, my name, Lord, in the panchayat, Lord, and that becomes a ground, Lord, for return. Without application of mine, Lord, this endorsement is given saying that there is a suit for injunction, therefore we cannot make entry. But Lord, no injunction is granted, Lord, by the city.
Yes.
The matter is still pending. That is submit substance. But if my lords were to see, Lord.
Where is your sale deed?
That paragraph 7 may also be carried this in. Paragraph 7 you want. It is submitted that survey number 48 bar 2 was awarded to Narayan and the new survey number was assigned 129 to the extent of 4 acres. It is submitted survey number 48 and 42, 48 bar 2 and 129 during the re-survey carried out during. So they admit, Lord, that 4 acres is given to them and 4 acres is given to my vendor. Okay, into 1.5 kilometers away. It is the part of the same survey. Divided and given to each of the joint owners of the property. Joint purchase.
Where is your sale deed? There's some rectification deed also.
Page number 39. Next year. Yeah.
So this pleading applicant also has joined in as a confirming party.
Yes.
In the sale deed.
Yes.
He has joined in as a confirming party.
Because he also wants after the taken precaution.
But the end problem. Please see the sale deed, sir. Please see the sale deed at annexure F. You are a confirming party there. Then who is this confirming party? Who is this confirming party? PC Murugesh and one name, sir.
ಶೆಡ್ಯೂಲ್ ಕೊಟ್ಬಿಟ್ಟು ಕನ್ವರ್ಷನ್ ಮಾಡಿ ಆ ಕನ್ವರ್ಷನ್ ಮಾಡಿ ಅದನ್ನೇ ಸೇಲ್ ಮಾಡಿ.
Where did you get this information that both of them are jointly purchased the property?
Paragraph 4 is statement.
Allah, our statement Allah. In your in your recitals in the sale deed.
ಇಲ್ಲ, ನಾವು ಕಾಪಿನೇ ಹಾಕ್ತೀವಿ, 10 ಕಾಪಿ. May I request you to kindly see paragraph 4. It is submitted that the property bearing of the fund so totally with the related situated at fund. It was purchased by Karnataka and this copy jointly under registered sale deed dated 3/4/1904. Out of which followed they partitioned it covered 4 acres to him and 4 acres other were joint purchase. And the further stated covered in paragraph number 7. Paragraph 5 also they say covered the eastern portion and the western portion allotted to each. Paragraph 5. And they entered into a compromise also. The compromise note, it was alright. After in 48 towards the eastern side were allotted to the land to an extent of 4 acres. Kilometer towards Sandhya. That is the cause of action for them not to say he is staying far away and he is trying to enter. See the summit substance of the entry. And the Panchayat Road without applying the mind word and the copy of the print without looking at the copy of the print, they give an endorsement to this fact. And the civil court has not granted any. Let them reconsider it, taking into consideration the amendments made in the print.
Already in the suit, you have arrayed only this developer as the defendant. What about the person who sold the property in their favor? Audrey, if that is your allegation, how is it that you have filed a suit only against the purchaser? What about the person who sold the property? You please see that plain. Only this developer is the defendant. This OS 106 of 2021 is also filed by you. How is it that only the purchaser is made a party defendant? What about the person who sold it? Huh? But you are saying that person Murugesan has sold it in their favor. You are admitting. You please see your plaint, sir. Paragraph 15. It is submitted that the defendant purchased the property from its vendor PC Murugesh under registered sale deed dated so and so. So you don't want to array him as a party defendant? Huh? Yeah, what are you people trying to do? Order on IA number 1 of 2021. This application is filed by one Sri CM Rudrappa seeking to come on record as a party respondent to these proceedings. Stop. It is the contention of the impleading applicant that he has filed OS number 106 of 2021 before the civil judge and JMFC, Anekal, against the petitioner herein, seeking a decree of permanent injunction in respect of the very same property for which the petitioner has approached this court. Stop. Learned Counsel therefore submits that the impeding applicant would become a necessary party to the proceedings. Stop. Next para. Learned Senior Counsel Shri S.M. Chandrasekhar, appearing for the petitioners, would fairly submit that the impeding application may be allowed. Stop. Next para. Consequently, the application is allowed. The Learned Counsel for the petitioner shall carry out the amendment in the cost title and furnish amended cost title within a period of 1 week from today. Full stop. Release this matter on 12th of July. You please come. Of July. We will dispose of the petition. Please come. Yes.
Appear for the petition, my lordship.
Yes.
My lordship, the applicant has filed an 1 Rule 10 impleading application, my lordship. We have filed a petition seeking for the relief to quash the order passed by the deputy registrar of cooperative society and
Savita, for impleading. Cooperative societies matter.
yes, my lordship.
Huh.
The liquidation, the deputy registrar has passed an order for liquidation, my lordship. So, and also it has directed the liquidator as second respondent as the liquidator. Agreeing the said order, we have seeking for the relief to quash the order of the deputy commissioner and as well as the learned joint registrar of cooperative society, my lordship.
There are only 3 persons agitating this matter.
Yes, my lordship.
At your instance, the same has to be considered, is it?
Yes, my lordship.
When all the others have accepted it.
Yes. No, my lordship.
Yes,
Actually, only out of 161 members, there are only 80 members who were called out on the special general body meeting, my lordship. In that meeting, in that out of 80 members, only 78 members have given agree with whatever happened in the general meeting has been agreed. Other
Correct.
2 has given the opposition, my lordship. But none of the other members have not been served notice by the special officer, my lordship.
Houdri, they have all accepted the fact that the society can be liquidated.
No, my
Only at
lordship.
the instance of 2 or 3%, how it can be entertained?
No, my lordship. Out of 161 members, only.
Cooperative society, sir, it does not belong to 1 or 2 individuals.
Yes, my lordship, I agree.
The majority of the members of the society have agreed for liquidation, and nothing more survives in the society. How it can be challenged by 1 or 2 members of the society?
My lordship, the fact is, out of 161 members, only 80
And who are
members
these
were.
including applicants?
They
They have
are
come to
also the
support you or against you?
Against us.
Mate? Matters called out. There is no representation for the including applicants who have filed IA number 1 of 2022. Stop. Reach this matter on 12th of July. Full stop. If there is no representation for the including applicants on the next date of hearing, the application will be dismissed and the matter will be taken up for final disposal.
Much obliged, my lord.
Come prepared. Yes. You said your father was not a defendant in the proceeding. What is the prayer in this petition? To quash the order at annexure R. Yes, passed under section 306. Yes. Yes.
The president, not being issued the notice, has not amended the matter.
Respond number 1 of the assistant commissioner by filing an appeal. Yes. For what? For what? With what prayer?
Saying that the property is in dispute has been acquired by him through the
ಮೂಲತಃ ಈಸೆ ಖಾನ್ ಕಾಸಿಂ ಖಾನ್ ರವರಿಗೆ ಸೇರಿದ್ದು, ಅದರಂತೆ ಸಂಪೂರ್ಣ ಮಾಲೀಕತ್ವವನ್ನು ಹೊಂದಿ ಅನುಭವಿಸಿಕೊಂಡು ಬಂದಿರುತ್ತಾರೆ. ಈಸೆ ಖಾನ್ ರವರು ತಮ್ಮ ಹಾಗೂ ಕುಟುಂಬದ ಅವಶ್ಯಕತೆಗಳಿಗಾಗಿ ಸದರಿ ಸ್ವತ್ತನ್ನು ಅರ್ಜಿದಾರರ ತಾತ ಸತ್ತಾರ್ ಖಾನ್ ಸಾಬ್ರವರಿಗೆ 1927 ಮಾರಾಟ ಮಾಡಿ ಅದೇ ಸತ್ತಿನ ಸುಬೋಧು ಕೊಟ್ಟಿರುತ್ತಾರೆ ಬಂದಿರುತ್ತಾರೆ. ಸತ್ತಾರ್ ಸಾಬ್ ರವರ ಮರಣ ನಂತರ ಮೇಲ್ಮನಿದಾರರ ತಾತ ಮತ್ತು ಕಾಸಿಂ ಖಾನ್ ರವರು 4 You purchased the property under a registered state.
My father, his father-in-law.
His father-in-law. When was that?
That was in the year 1951.
as per the annexure given. This is page number 13. It is D,
1952.
and F.
D, what is annexure E?
Annexure E is also same, that is of different measurement. Same problem. Joining the right.
Same date, no, ಅಲ್ಲ.
Oh, different date.
30 ಅಕ್ಟೋಬರ್ 63.
Then again, in 66.
Annexure F.
Annexure F.
Hmm.
66. Again, further portion of structure by my father. Accordingly, the Dada was handling in my father. 1956.
There is one more document, annexure G.
Annexure G is there is some difference in the measurement, and therefore that was also rectified. So annexure G. And the father standing in the name of my father, 1957. Till date. Till date. Till the Kata was cancelled by the Assistant Commissioner. The Kata was standing in mind. Respondent number 1 has come up with a disclosure by stating that there is a settlement in OS number 23 for 1960, and as per which that is the reference given by the Assistant Commissioner in the order as per the nature of the order. That is the question.
Please read this paragraph just above the operative portion in page number 70.
Yes, sir. Yes, sir.
ಎರಡು ಎದುರುದಾರರ ಪರವಾಗಿ ಲಿಖಿತವಾದ ಎಸ್
ಮೇಲ್ಮನವಿಯನ್ನು ಪ್ರಕರಣವಾಗಿ ಪರಿಗಣಿಸಿ ಉಭಯ ಪಕ್ಷಗಳಿಗೆ ವಿಚಾರಣೆಗೆ ಹಾಜರಾಗಲು ಸೂಚಿಸಲಾಗಿದೆ. ಹಾಗೂ ಪ್ರಕರಣಕ್ಕೆ ಕಡತದೊಂದಿಗೆ ವರದಿ ಸಲ್ಲಿಸಲು ಒಂದನೇ ಎದುರುದಾರರಿಗೆ ನೋಟಿಸ್ ನೀಡಲಾಗಿದೆ. ಎದುರುದಾರರ ಪರವಾಗಿ ಯಾರೂ ಹಾಜರಾಗಿರುವುದಿಲ್ಲ. ಹಾಗೂ ಅಂತಿಮ ವಿಚಾರಣಾ ದಿನಾಂಕದವರೆಗೆ ಆಕ್ಷೇಪಣೆ ಹೇಳಿಕೆ ವಾದ ಮಂಡಿಸುವುದಿಲ್ಲ. ಹಾಗೂ ಒಂದನೇ ಎದುರುದಾರರು ಮೂಲ ಕಡತ ಅಥವಾ ವರದಿ ಸಲ್ಲಿಸುವುದಿಲ್ಲ. Even first respondent, that is yes, ಸಲ್ಲಿಸುವುದಿಲ್ಲ. ಈ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಹಲವು ದಿನಾಂಕಗಳನ್ನು ವಿಚಾರಣೆ ನಡೆಸಿ ಹಾಗೂ ಪತ್ರದಲ್ಲಿ ದಾಖಲೆಗಳನ್ನು ಪರಿಶೀಲಿಸಿ ಅಂತಿಮವಾಗಿ ಆದೇಶಕ್ಕೆ ತೆಗೆದುಕೊಂಡ ಅಂಶಗಳು ಲಭ್ಯ ದಾಖಲೆಗಳ ಪರಿಶೀಲನೆಯಲ್ಲಿ ಈ ಸರ್ಕಾರಗಳು ತಮ್ಮ ಇತರ ಅವಶ್ಯಕತೆಗಳಿಗಾಗಿ ಸದರಿ ಸ್ವತಂತ್ರ ಅರ್ಜಿದಾರರಾದ ಮದಾರ್ ಖಾನ್ ಸಾಹೇಬರ ಬಗ್ಗೆ ರಿಜಿಸ್ಟರ್ನಂತೆ ದಿನಾಂಕ 30/5/1927 ಮಾರಾಟ ಮಾಡಿ ಅಂದೇ ಸ್ವತ್ತಿನ ಕಂಡುಬರುತ್ತದೆ. ನಂತರ 1957 OS ವಿಚಾರಣೆ ನಡೆದು 1957 ಹೀಗೆ ಮೇರೆಗೆ ನಡೆದ ಕ್ರಯ ವಗೈರೆ ತಪ್ಪಾಗಿರುವುದರಿಂದ ರದ್ದಾಗಿರುತ್ತದೆ. ನಂತರ ರಾಜಪತ್ರವಾಗಿರುವುದು ಕಂಡುಬರುತ್ತದೆ. This document is not in existence at all. This OS number 623/1960. And now the respondent number 1 has come up with other documents.
Yes. Now let us read the provision in 306, section 306.
Power of execution of order, etc. Municipal Council.
Yes.
If in the opinion of the Deputy Commissioner, the execution of an order or execution of town municipal council or the doing of anything which is about to be done or is being done by or on behalf of a town municipal council is unlawful or is causing or is likely to cause injury or harm or to lead to a breach of the peace, he may by order in writing under the case of suspend the execution of violation of the prohibited doing thereof. When a deputy commissioner makes any order under this section, he shall forthwith forward to government and to director of municipal administration and to the municipal council affected thereby a copy of the order with the stated reasons for making it, and it shall be in the decision of the government to rescind the order or to direct that it shall continue in force without modification permanently or for a period as it provided that no order of the constitutional falls under the section of the confirm the events of unpaid by the government without reasonable office.
So you please tell me, sir, how could this provision be invoked for getting the name of your party entered in the Kata register? This is not the provision which could be invoked. The provision is only for enabling the deputy commissioner to consider an order or resolution of the town municipal council. If it is permitted to be carried out, it would cause public annoyance. What has that got to do with the Kata transfer? And which order are you questioning? It's all well settled, sir. Aden vastalladu. And please understand, even if the power is vested, it is only for suspending the order. The copy of the order should be sent to the government. Government should reconsider that one and then decide whether it has to be sustained or modified or set aside. No such procedure has been followed by the assistant commissioner. Please read the provision. It is only a power enabling suspension of an order or resolution passed by the municipality. Yes. Okay. No. No. Sir, it's a civil dispute that has to be resolved in the civil court. Adi, as and when you succeed, your name will be entered in the Kata register. Sir, you read out the provision now. So therefore, first you'll have to convince the court that yes, this authority had the power to pass such an order. No. No, sir. No, sir.
Then it is limited back to press inquiry. That you possibly can see. That is the order.
There is no such power. There is no such power vested with the assistant commissioner to have passed this order. ಎಷ್ಟು ಸರಿ ಪ್ರಾವಿಷನ್ ಹೋದ್ರು ಅಷ್ಟೇ ಮೀನಿಂಗ್ ಬರೋದು, ಏನು ಅದೇನು ಬದಲಾಗಲ್ಲ. ನೋ ಸರ್, ಮೆರಿಟ್ಸ್ ಮೇಲೆ ಹೋಗಕ್ ಆಗದೇ ಇಲ್ಲ ಈ ಮ್ಯಾಟರ್ ಅಲ್ಲಿ. ದಿ ಕ್ವೆಶ್ಚನ್ ಈಸ್ ರಿಗಾರ್ಡಿಂಗ್ ಏನ್ ಕಮಿಷನ್ ಮಾಡ್ತೀರಾ, ಏನ್ ಮಾಡ್ತೀರಾ ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ? It's a provision, sir, that cannot be changed in any way. when the assistant commissioner could not have passed this kind of an order, invoking the provision contained in section 306, where is the question of learned counsel for the petitioner has pointed out to section 306 of the Karnataka Municipalities Act, 1964, and submits that the impugned order could not have been passed by the assistant commissioner, since the provision enables the assistant commissioner, who is a delegate of the powers which were originally conferred on the deputy commissioner, only to interfere in respect of orders or resolutions passed by the municipality, which would cause public annoyance if permitted to be executed. Stop. The contesting respondent herein invoked the said provision for having his name entered in the Kata register by removing the name of the petitioners, which were in the records of the municipality for many decades together. Stop. Next para. At this juncture, learned counsel for respondent number 1 seeks for a short accommodation. Full stop. Release this matter on 12th of July. Madi. Yes. Or on IA number 1 of 2023. This IA is filed seeking amendment in the past title, more particularly the description of respondent number 2, Tahsildar. Stop. It is submitted that the jurisdictional Tahsildar is the Tahsildar, Bangalore South Taluk, and not Magadi Taluk, as was in the past title. Stop. Learned counsel for the petitioner has drawn the attention of this court to the record of rights furnished along with the writ petition, and submits that the taluk shown therein is Bangalore South Taluk and not Magadi Taluk. Full stop. However, learned counsel admits that it's the mistake of the petitioner to have wrongly shown the Tahsildar as Magdi Taluk. Full stop. Next para. Accepting the submission of the learned counsel for petitioner, the application is allowed. Full stop. The petitioner is permitted to carry out the amendment in the cost title accordingly. Full stop. Office is directed to make necessary correction, not only in the cost title, but also in paragraph number 2, and issue a fresh certified copy. Huh? Hmm. You know what is the matter about? Huh? Who approached the executive officer? For I think we will hear it. Perfect. Read it matter on 12th of July 2023 for orders for preliminary hearing. All other matters next week. Wherever interim orders are to be extended, you please mention it will be extended. Huh? Serial number 38. Who is on the other side? Adun matra after 2 weeks. ಅಲ್ಲ ಏನ್ ಮಾಡ್ಬೇಕು ಹೇಳಿ ನೀವು? ಅಲ್ಲ ಏನ್ ಮಾಡ್ಬೇಕು? You please tell us what can be done. Sir, a date was given. What can we do? 2 ಸರಿ ಡೇಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ನೀವು ಅವ್ರು ತಿಳಿಸ್ಲಿಲ್ವಾ? ಮತ್ತಿನ್ನೇನ್ ಮತ್ತೆ? No.